Hello, chat. Sorry, did not get my drink ready. I needed a second to get that done. Sorry about that. So I figured I'd keep you guys in suspense for a minute. So not really a lost boomer, it's just I didn't have anything to drink, and my throat and my mouth will be parched if I don't get it ready. There's only one countdown. It's only a 30-second one. So that's the one that StreamYard provides you, and you can loop it. Do I get my iced tea with heavy cream? No, that just sounds absolutely disgusting. No, and I drink tea. Generally, it's iced. It's not like sweet tea. It's just iced tea, cold tea, which is really good. I like the flavor of tea, which I know a lot of people don't, but I actually do enjoy it, believe it or not. So he can't stop winning. Okay, yes, guys. So welcome. My name is Potentially Criminal, also known as Sean. I am a defense attorney out in Cleveland, Ohio, in the Cleveland area. And we're going to talk about this today because it's criminal related, because it's a case that is being waged against former President Trump. Now, I could come run in here and be like, oh my God, guys, it's Dub City for Donald. This is good, but it's not a this is not a dismissal on the merits. This theoretically could come back at some point. So it's not gone. I'd love to be able to say that, though. Dub City, population one Mr. Donald John Trump. I'm doing my Vince McMahon style, but it's not going to work that way. It's not going to work that way. I know you're making fun of Nick. I'm just saying that was disgusting. That whole thing doesn't make sense. Yes, anything goes. Yes, I'm not tired of the winning yet. Sounds like more like PPP every day. Well, or maybe PPP sounds like me. Dun, dun, dun. So, yes, the documents case against former President Trump was dismissed today. And it was dismissed because of how the Special Counsel Jack Smith was appointed. And I hope you guys notice in the background is a cackling Clarence Thomas, which I think is very apropos given the Trump v. United States immunity opinion that got released a while back. Now, what does this actually mean? It's important. It's one less case on the docket. But it's not gone away. It could still come back. It could still come back, guys. So while you're happy, the fight has been postponed. It wasn't a TKO. We just happened to postpone the fight to a later date. Now they may never fight again. I'm too skinny to be PPP. I think PPP is bigger than I am. Or I'm bigger than PPP. I bet if we were sitting next to each other. Jack Smith got felted. Yes, he did. He got felted right now. This is a bit of a fucking embarrassment. And we are going to discuss this. But as I stated, guys, this isn't a dismissal of prejudice. This isn't a dismissal on the merits. This is a procedural dismissal, meaning the government can always come back. And we're going to talk about that. So I don't mean to scare you guys. And red pill it, doom pill it. But assuming the 11th Circuit upholds this, and then it gets upheld by the Supreme Court, the Department of Justice can come back and refile it. There's nothing stopping them. So let's go from there. So let's get started. This is a long one, guys. We're gonna go through it. There's parts we might be able to skip, but it is 93 pages long. So for some of you that might think, oh my God, Judge Cannon just got caught up in the fervor of him surviving the assassination attempt and the immunity decision and all of that, and she's just like belted it out. She didn't knock this out over the course of a couple of days. This has been a long time coming. It just happened to get released today. So don't I don't think this is meme magic. This was already in the this is already in the works. This is already in the works. Chris says, "You're scaring me." I'm not trying to. So with that, let's get started. Let's get started and figure this out. We got a long way to go. Okay, there's 2 super chats we'll read first since they're here. Anything goes for $2 says, "No, fight Anna, Vito, and Riley. Be friends." Well, I haven't. When was I fighting Riley? Osmosis Jones says, "What's your take on why Rings of Redemption was exposed for watching BBC shemale corn on Hamster?" When did that happen? I haven't heard about that, and that's not even on the farms, I don't think. Hold on, let me see. Is that on the front page? Oh my god! It's real! Oh no, Wings! No! No! Oh, you were doing so good for so long. Boogie was just being the shit magnet. Oh no, I have no comment yet because I just literally learned about it. So, oof. 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 New topic. No, we're not doing that tonight. We are not covering that right now. Oh. Anyways, let's move on to the opinion. It's time to roll. I don't know if I'll be able to focus after having that rolling around in my head, but oh, come on, Jordy. I actually like Wings. I think Wings is actually pretty cool. I like him. I think he'd be fun to hang out with. I think he'd be fun. All right, guys. All right, chattel. Here we go. It's time. Done today, the 15th. United States District Court, Southern District of Florida, the West Palm Beach Division. United States of America versus Donald John Trump. Waltine Nada and Carlos de Oliveira. Now, these two are Trump's aides. So here we go. Order granting motion to dismiss superseding indictment based on Appointments Clause violation. So former President Trump's motion dismissed based on the unlawful appointment and funding of Special Counsel Jack Smith is granted. In accordance with this order, the superseding indictment is dismissed because Special Counsel Smith's appointment violates the Appointments Clause of the United States Constitution, specifically Article 2, Section 2, Clause 2. Special Counsel Smith's use of a permanent indefinite appropriation also violates the Appropriations Clause under Article 1, Section 9, Clause 7. And that is a bit of an issue when you think about it, because he's been operating as like a permanent special counsel, which means he should probably be a regular counsel. I'm assuming that's the full argument she's going to make here. We'll get to it. But the court needs not address the proper remedy for that funding violation, given the dismissal on Appointment Clause grounds. The effect of this order is confined to this proceeding. I wonder if she could be like Hawaii judge. It could have been like, nationwide injunction, Jack Smith. I'm nuking the DC case. That would have been epic. I would have been like, ooh, child. But she didn't do that. So it's only for this case. Only for this one. Only for this one right here. Only this one, chat, sadly. So this motion challenges the legality of the special counsel in 2 respects, both of which are matters of first impression in the circuit, and both of which must be resolved. The first is a challenge under the Appointments Clause, which provides the exclusive means for appointing officers of the United States. The Appointments Clause sets as a default rule that all officers of the United States, whether inferior or principal, must be appointed by the President and confirmed by the Senate. It then goes on to direct that Congress may by law vest the appointment of such inferior officers as they think proper in the President alone, in the courts of law or in the heads of departments. So Congress can delegate that. And that's in the Constitution. So it's something they are inherently allowed to do. This goes all the way back to the beginning. They are allowed to do that. And guys, when you see id, that just means they are repeating the reference above. So they're going back to, based on this, I can read it. Article 2, Section 2, Clause 2. They're going back to that and they keep referencing it. That's why you keep just seeing id. So, for purposes of this order, the court accepts special counsel's contested view, and because they're arguing that he is an inferior officer, not a principal one. I think that makes sense. I think that's actually a fair argument from Jack Smith, that he is an inferior officer. I don't disagree with that argument. The court expressed reservations about that proposition and addresses the arguments below. Sounds like Judge Cannon and I may disagree. The second motion is ruin the Appropriations Clause, which prohibits any money being drawn from the Treasury unless such funding has been appropriated by an act of Congress. And that makes sense. You're not allowed to receive funding without authorization. Just like, guys, when you're at work, you can't make a purchase order without permission. Now, they bring up, is there a statute in this? This brings it as a question. Is there a statute in the United States Code that authorizes the appointment of Special Counsel Smith to conduct the prosecution? After careful study of this seminal issue, the answer is no. None of the statutes cited as legal authority for the appointment, 28 U.S.C. 509, 510, 515, and 533, give the Attorney General broad inferior officer appointing powers or bestow upon him the right to appoint a federal officer with the kind of prosecutorial power wielded by a special counsel. Nor do the special counsel's strained statutory arguments, appeals to inconsistent history, or reliance on out-of-circuit authority persuade otherwise. The bottom line is this. The Appointments Clause is a critical constitutional restriction stemming from the separation of powers, and it gives Congress a considered role in determining the propriety of vesting appointment for inferior officers. This special counsel's position effectively usurps that important legislative history, transferring it to a head of a department, and in the process threatening the structural liberty inherent in the separation of powers. If the political branches wish to grant the Attorney General power to appoint Special Counsel Smith to investigate and prosecute this action with the full powers of a United States attorney, there is a valid means by which to do so. He can be appointed and confirmed through the default method prescribed in the Appointments Clause as Congress has directed for the United States attorneys throughout American history. Meaning, we already have something set. And it also says, see 28 U.S.C. 541. Or Congress can authorize his appointment through enactment of a positive statutory law consistent with the Appointments Clause. And they can enact the law if they want to, or they can appoint him. There's two ways they can already do this. Nero says, yes, Jack Smith is inferior in all ways. Nero says, but Sean, if I own my business, who do I get permission from for a purchase order? I think you're SOL at that point. Also, guys, I think we're live on Rumble right now. Let me know if it's working or not. We should be up over there. But nobody's over there and nobody's responded. It's all lonely. Let's keep going. So the order proceeds as follows. After laying forth the pertinent factual and procedural background leading to the motion, the court summarized the legal principles underlying the Appointments Clause and the separation of powers doctrine on which it rests. The court then surveys the statutory structure of the Department of Justice, focusing on provisions which grant the Attorney General appointment authority. Following that contextual summary, the court engages with the context, text, and structure of each statute cited in the appointment order. Finding no officer appointing authority in the cited statutes and seeing no reason in the mixed historical record to deviate from the absence of such authority, the court addresses the Supreme Court's dictum with respect to those statutes in United States v. Nixon. As Nick, and guys, this is actually a very interesting case to read because it all revolves around the issues that are there and how things unfolded. It's very, very interesting about all of it. It covers it's all about the Watergate scandal. There were multiple issues there that the Attorney General appointed a special prosecutor, and then later Nixon said, I need you to fire him. And that's also what you guys may have heard of, is also known as the Saturday Night Massacre, because not only did the Attorney General quit, but his deputy quit. And then the special prosecutor was fired. And from there, things kind of spiraled out of control because the new special prosecutor subpoenaed the tapes relating to Nixon and all the tapes that may have been doctored or maybe missing. There were the edited transcripts and parts of 20 conversations. So that's where Nixon comes from in this and why we see it. And that's where this all comes from there. But as we keep going, as Nixon's decision and record bear out, the Attorney General's statutory appointment authority, or the matter of the Appointments Clause more generally, was not raised, argued, disputed, or analyzed. At most, the Supreme Court assumed without deciding that the Attorney General possessed statutory appointment authority over the special prosecutor involved in that action. Following the discussion of Nixon and related out-of-circuit precedent, the court turns to the question whether Jack Smith is a principal officer requiring presidential nomination and senatorial consent. She says, on an issue, there are compelling arguments in favor of that designation, given the regulatory framework. This court rejects the position based on the available Supreme Court guidance. It's a very brave thing for a district court judge to say. Fuck the Supreme Court. Court then entertains a question of remedy, concluding that dismissal is the only appropriate solution for the violations. And finally, the court considers the Appropriations Clause challenge to the funding of Jack Smith, concluding for many of the same reasons he has not authorized the appropriation of money to be drawn for the expenses. That'd be funny if there's like a letter that goes out afterwards to like all these people working for the case, all the prosecutors, they get a letter like, hey, all that money we gave you, you have to send it back. Just a little knock at the door like, yeah, hi, I'm with the IRS. We're here to get that money back we gave you. That would be so funny. That would be so funny. So anyways, we'll go to the procedural history. The procedural history of this is covering the beginning of the case. And we're not worried about that. Yes, Trump is accused of hiding new special secret documents. Oh my God. What we are doing is we're going to move forward here, and the arguments are actually important here. So the basic argument is that the Appropriations Clause means basically he's acting as an indefinite appropriation reserved for an independent counsel under a statutory appropriation that does not apply to him. And yes, he's basically acting like as a permanent prosecutor, kind of like when Ken Starr was independent counsel. That's a little different, kind of like Robert Mueller. He was operating as an independent counsel. This is different. And those guys were operating, could do whatever they wanted. That's said, Jack Smith is opposing these. As the Appointments Clause, he urges the Attorney General exercise authority under 28 U.S.C. 515 and 533, citing the decision in Nixon and D.C. Circuit Authority historical practice. And if you guys want to see what that means on electronic filing, and this means the 374th entry, because even court entries show up. So that's docket number 374, pages 1 to 16, if you want to go look for it on Pacer or Court Listener. So When it comes to the appropriations, Smith argues that he lawfully draws from the indefinite appropriation for independent counsels because he retains substantial independence from the Attorney General and was appointed pursuant to other law in the form of the same statute cited above. Ooh, it's a little sunny out today. We need to fix that. I got some glare. Sorry. Yeah, much better, much better. Actually, we're going to make this a little bigger. In any case, she says, in any case, Smith continues, any appropriations defect should not result in dismissal because the department could have lawfully drawn funds from another source to investigate and prosecute this. And that's ultimately what Jack Smith is saying. Even if you have a problem with my funding, the DOJ can have funding. It might have extra funding sitting around, all the different things that could happen. We can refund the case at any point in time. So this shouldn't be dismissed for that reason. That's the argument Jack Smith is waging. And it's one that does make sense. Basically, his argument's a harmless error. I could get money tomorrow from somewhere else if that's the problem. So the actual appointment order. So by order number, and this is the order number from the Attorney General, 5559, by Attorney General Merrick Garland, he appointed John L. Smith, Jack Smith, an attorney from outside the United States government, to serve as special counsel for the United States Department of Justice. Smith was not nominated by the president or confirmed by the Senate. You can already see where she's going when she says stuff that doesn't happen. So the appointment order is made a part of this record and referred to herein as the appointment order. So they're just referring to it there, okay? And if you guys want to see it, you can go to the website here and you can get the press release and all of it. The order states Garland is vested, meaning he has within him and given to him with appointment authority to issue the appointment pursuant to 28 U.S.C. 509, 10, 15, and 33. The appointment order then authorizes special counsel to conduct 2 specified investigations and to prosecute crimes arising from those investigations. The first relates to the efforts to interfere with the lawful transfer of power following the 2020 presidential election. Ow. The second is referenced and described in response for the motion for judicial oversight and relief in Donald Trump v. United States, as well as any matters that arose or may arise directly from the investigation or that within the scope of 28 CFR, means the Code of Federal Registers, which is a separate thing, which is where the Code of Federal Regulations are. And the only indictment at issue in this order arises from the later investigation. So they initially said, look into that. And they're like, oh, look into this too, Jack. With respect to funding, all parties agree that the office has been funded using a permanent indefinite appropriation established within the DOJ to pay all expenses by an independent counsel appointed pursuant to it. This is a limitless appropriation, meaning they can pay, and they can always take money. They can always do whatever they want. It never goes away. So that is an interesting. Max is saying here, try this credit card instead. That's actually not the thing. The court's saying you're not allowed to pay with that one. And the DOJ, to be fair, Jack Smith is saying, fine, you don't want me to, like, okay, you don't accept Discover here? Fine, here's my Amex. So let's keep going. Let's keep going. And as of September 2023, Jack Smith's expenditures reflect $12 million in direct expenses drawn from the appropriation, plus an additional $11 million in component expenses. attributable to this investigation also drawn from the indefinite appropriation. Guys, that includes a lot of things. I mean, you're paying for people, materials, office, like you got to get an office set up. We have to get phones. We have to have a copy machine. We have to get paper and toner. He's not allowed to go down the hallway to the DOJ and just like wheel out a fucking cart. Like he just can't walk in there and just be like load stacks of paper on the thing and stealing boxes of pens and coffee cups and like walking out the front door of the DOJ, just like, and then stand there and like throw all the shit in his car and go to the other office. They're not allowed to do that. There have to be definitive breakdowns of that. Amex sucks. Oh my God. We're going to fight over everything. It is the internet. Jerem70. Hey, man. Good to see you here. I think your new name. Welcome stopping by. Says, Sean, get down. Destiny has you in his sights. Okay. Stephen Kenneth Bennell II. I want everyone to die if they don't like how I vote. Okay, Destiny. As he said, he would rather have 10,000 men have sex with his wife than let Trump win or whatever it was. And you're like, not really sure that's not a Chad move there, homie. But okay. Oh, not sure. Oh, not sure if that's really a thing. So the special counsel regulations. At the end of the appointment order, there's the following reference to Department of Justice regulations. And it says section 600.4, 600.10 of Title 28 of the Code of Federal Regulations, the CFR, are applicable to special counsel. Those regulations hereinafter referred to as the regulations. I love how we go through all that. We give it a three-word name, and then or as regulations are enforced today, and they stem from a final rule promulgated by the Office of Attorney General in July 1999 after Bill Clinton, and later codified at 28 CFR. Notice of the final rule, and guys, remember that we talked about this with the ATF before. You have to go through notice of rulemaking. You have to follow the Administrative Procedures Act. There's all things you have to do there, and you have to have a comment period. You have to address the comments. Peacenik says, yeah, I just thought he didn't go live on here ever. I've had all kinds of problems. The one account has more followers. Yeah, because I didn't understand how Rumble does stuff confusing over there, okay? Yes, follow the one that's all one word. And yes, Rumble is now probably going to be a lot more airing of stuff. They helped me fix the problems. So the regulations replace the procedures for the appointment of independent counsel pursuant to the Independent Counsel Reauthorization Act of 1994, and it cites statutory authority for the 7 statutes in 28 USC 509, 510, 515 through 519. Special counsel regulations consist of 10 sections spanning various topics, ranging from jurisdiction, power, staffing, conduct, accountability, among others. As the most, and guys, big thing, staffing. How do you staff this? How do you pay for them? As most relevant here is explored below, the regulations do this. Declare the grounds for appointing a special counsel. Direct Attorney General establish jurisdiction of a special counsel. Meaning you have to give him a mission statement. And it's through a specific factual statement to the matter to be investigated. So you can't just tell him, go be special counsel. I want you to look at X, Y, and Z, a specific thing. That the special counsel may wield within the scope of his or her jurisdiction the full power and independent authority to exercise all investigative and prosecutorial functions of any United States attorney. And he's not subject to the supervision of any DOJ official on a day-to-day basis. Just like the U.S. attorneys are not on a day-to-day basis. There's nobody they report to, but they are subject to supervision from the DOJ just on a broader basis. permit the Attorney General to remove the special counsel, but only for misconduct, dereliction of duty, incapacity, conflict of interest, or for other good cause. It gives the special counsel the ability to determine whether and to what extent to inform or consult with the Attorney General or others within the department about the conduct of his or her duties. They permit the Attorney General to seek explanations of special counsel about any investigative or prosecutorial step, meaning he has the right to go to Jack Smith and say, "Why are you doing this? You have to tell me." It dictates that the special counsel shall comply with the rules, regulations, procedures, practices, and policies of the DOJ, which makes sense. There has to be some sort of grounding principles. Authorize the Attorney General on a permissive basis and after review to determine that a particular action should not be pursued because it is so inappropriate or unwarranted under established practices, except that if he makes this determination, he must notify Congress of his decision to countermand the special counsel. That one's a big one. If he decides it's not a big deal, he has to tell Congress about it. He can't just shh and just push it off into the dark. So she says, this down for present purposes, the special counsel regulations mandate the counsel be selected from outside department and they empower the outside attorney to investigate all investigative and procedural functions, prosecutorial functions of any U.S. attorney within his jurisdiction. So this is where she gets to Independent Counsel Act, Morrison v. Olson, and the lapse of the Independent Counsel Act. So they talk about the promulgation of special counsel regulations. There was a statute that by 1999, because they talk about 94, there was a statute that expressly authorized the appointment of independent counsels. That statute was the now expired Independent Counsel Act that was passed as part of the Ethics of Government Act of 1978. Remember, the government, well, they had a big credibility crisis back then. Well, they still do. Like, let's not lie. They still have a massive credibility crisis. Just ha 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 ha. Oh God, yes, that's oof, oof, oof. Hmm. Excuse me. Now, under the now expired Independent Counsel Act, Congress authorized the Attorney General, after finding grounds to believe investigators warranted, to request a 3-judge panel appoint an independent counsel to fully investigate and prosecute violations of federal criminal law by certain categories of people, including the presidents and former presidents, for a year after leaving office. Under that framework, Judicial Division would appoint an appropriate independent counsel for outside the United States and define that independent counsel's prosecutorial jurisdiction. Once appointed, the independent counsel had the full power and independent authority to exercise all investigative and procedural functions and powers of the United States Department of Justice, the Attorney General, and any other officer or employee of the Department of Justice. The legality of the Independent Counsel Act took center stage in Morrison v. Olson in 1988. A suit challenging the statute under the Appointments Clause and other constitutional provisions and principles. In 1994, which came after Morrison, Congress reauthorized the Independent Counsel Act in accordance with its 5-year sunset provision. They said, but then in 1999, when the authorization returned to the legislative table and in the wakeful meaning of the meaningful criticism of the act, which, guys, it is. Remember, this is the aftermath of Bill Clinton. The independent counsel had gone on for a while. Guys, like I said, remember Ken Starr. and everything that went on with that. And then aside from Ken Starr, you have a lot of people we may have heard of before, including like George Conway, Kellyanne Conway's husband. Oh, actually, wait, what is his name? Kellyanne Conway is a former counsel of the President of the United States. Her husband was one of the attorney. Like he's kind of like a never Trumper tool now, but he was part of the attorneys that were involved in all the lawfare on the Republican side trying to get rid of Clinton. But in addition to that, you had attorneys like, you talk about this thing here, the sunset provision. Who was this written by? Brett M. Kavanaugh in the Georgetown Law Journal, 1998. We're starting to see these things. And also at that time, guess who was already there? Clarence Thomas was already there. But he would have been in a minority at that point. Congress let the act expire and has never reauthorized it. At that time, then Attorney General Janet Reno opposed reauthorization in a public statement to Congress. Reno expressed the various criticisms of the act and called for a return to what she says a non-statutory independent counsel built on a set of pre-existing regulatory procedures that were presented on the Attorney General's authority to appoint a special prosecutor in situation demands. A day after the Independent Counsel Act expired, the same regulations came into being. As noted, the special counsel regulations have remained in place. Is chat boring you, Sean? Jeez, no. Have remained in place without change since their effective date in July of 1999, with at least one successful legislative effort in 2019 to fix them. No special counsel statute exists today, and no such statute existed in November of 2022. So the background legal principles. Okay, so Article 2, Section 2, yes, the appointment power. So they say the Appointments Clause prescribes the exclusive means of appointing officers of the United States. They say an officer is distinct from a non-officer employee is any appointee who exercises significant authority pursuant to the laws of the United States. That's why there are levels to like what you're doing, what types of people are officers, and how they could be addressed, how they could be removed. Because if they're an officer, they could get dismissed. The president can fire them. If they're a non-officer employee, probably like in the civil service, you're protected. So that's why the underlings never go anywhere. But like James Comey, Andrew McCabe, those guys could get canned by Trump. But somebody like Peter Strzok, he's in the civil service, he's protected. All right, be nice to Sean and tell him you can't see his nipples. Luke says, I still think Clarence is a minority, to be fair. Yes, but guys, in 1999, Clarence Thomas, and even 1988, all that, he was still a minority as far as opinions on the court. People would always like read him and say, wow, isn't he being all wacky and zany? But now Clarence is in charge. He's like, I am in charge. Now he's looked around at everyone. He looked at Sotomayor and he's like, do you feel in charge? But I'm the wisest Latina. Do you feel wise? And she's like, yes. And he's like, no, you don't. I know, KLF, he's referring to his skin color. Wait, he's black? I didn't see it. I didn't know. I didn't know. So They point out the exercise significant authority pursuant to laws in the United States marks not the line between principal and inferior officer, but rather the line between officer and non-officer. So inferior officers exercise significant authority. So the Appointments Clause establishes two classes of officers, principal and inferior. Principal officers must be appointed by the president with consent and advice of the Senate. That mechanism is the default manner of appointment for principal and inferior officers. But the Appointments Clause allows for another way, and it does suit throw called the Accepting Clause, meaning where it says accept. That clause allows Congress by law, and as it thinks proper, to vest the appointment power in three places and only three places. Meaning Congress is allowed to do that and go, hey, you know what? We're naturally not allowed to delegate out power to the other branches, but we are allowed, you, Mr. President, we're going to delegate this out to you. Why? Because we can't. You got to get your people staffed. Quit coming knocking on our door every 5 minutes. So here, go screw yourself for 20. Go screw yourself. And the president alone in the courts of law are in the heads of departments. But a decision to dispense with presidential appointment is Congress's to make, not the president's. So Congress has to do it, not the president just taking it from them. And if Congress wants that to happen, they have to pass legislation saying, we're allowing the head of the Department of Education to do this. They can't just let him do it and not oppose it. They actually have to allow it. If they don't allow it, that's problematic for them. Let's see here. Where are we at? Importantly, the framers considered and initially maintained a proposal by which the president alone would have the authority to appoint all officers in all cases. That proposal was replaced in 1787 when Governor Morris moved to add the Accepting Clause, Article 2, which was adopted shortly thereafter. That left Congress an important, though circumscribed, role in vesting appointment authority for inferior officers. The framers' rejection of unilateral executive appointment authority traces its roots to the American colonial experience with the English monarchy. And the framers' desire to limit executive aggrandizement by requiring the shared legislative and executive participation in the area of appointments. You guys, hold on. It's getting warm here. I'm going to turn on my fan. I wasn't going to let you guys watch me act like a moron fighting with the ceiling fan. So, yes, Judge Cannon's giving Jack Smith the proverbial Pringles can, more or less. More or less. So, all right, where are we? For these reasons, the Supreme Court has emphasized the Appointments Clause is more than a matter of etiquette or protocol. It is among a significant structural safeguard to the constitutional scheme. It is rooted in the separation of powers fundamental to our system of government and to limitations built into that structure. Yes, but Congress, the Senate has to consent to the appointment of principal officers. And Congress has the ability to give the president the ability to appoint people without coming to them, but Congress has the power to take that back if they want. It's allowing that back and forth, that without allowing one party to get too strong, they're always in constant battle. And if they're in constant battle, then they can't harm the people. Well, hopefully that was the deal. It's not working out that way. The appointment clause is among us. It's among us. Yes. It's to prevent one branch from aggrandizing itself at the expense of another, but that's always a separation of powers. So, the Appointments Clause also preserves the Constitution's structural integrity by preventing the diffusion of the appointment power, thus enhancing democratic accountability, and it does. People can cry to Congress, and Congress can enforce things and get what they want done. So, turning the accepting clause more specifically, the Appointments Clause requires any congressional decision to vest inferior appointment power must be made by law, meaning statutory law, as all parties rightly agree, and they all agree on this. But they're saying what actually makes it a law? What specifically does the law have to do? And they're saying this law is a means by which Congress, in the words of the clause, can express its determination. Thus, Congress retains a critical role in determining which officers create and whom to invest with the appointment power. That role cannot be usurped or minimized, for doing so would breach the national fundamental law of separation of powers and violate the principle that all legislative power should or shall be vested in, and you're left with Congress. That's where it all goes. Put another way, there can be no expansion of the vesting power beyond what is permitted in the clause. And there can be no usurpation of the appointment power by indirection. They state the accepting clause must be strictly construed and not extended by application. That's just pausing is still the key principle so far. The following points stand out. The appointment clause reflects a system by which the executive and legislative branches jointly participate in appointments. From there, Congress retains a pivotal role in the appointment sphere, a role that cannot be usurped or expanded. The Appointments Clause creates a mandatory exclusive procedure that must be enforced according to its plain meaning without exception. And I would argue I think this is for us as much as it is for anybody in court, because they'll read it and they'll understand it. But I think this is like a hey dummy moment for us. But we don't really know. I don't know how a judge does this normally, but I think it's very interesting. She hasn't really done this in the other cases before. Shelby's saying hello. Hi, Shelby. How are you? Oh, Muslim people, did YouTube take me out? There's an additional background legal topic which concerns the clarity which Congress must speak. And that's what we talk about by law, like what Congress must do. In other words, should courts apply a clear statement rule in this context? The Meese amicus brief, and that was done by Edwin Meese, the Attorney General for Ronald Reagan, urged the application of such a rule, arguing Congress to speak clearly for determining a statute permits deviation from the default appointment method is warranted, and that's to preserve the structural powers, the separation of powers, foundation, and federalism features upon which the Appointments Clause is built. I hear a poop. Hold on, real quick, guys. Content Lasagna said they could bring it again. Yes. Oh yes, Content Lasagna. It's not dismissed with prejudice. So this is a proceed. Okay, we're gonna stop real quick, just so we're clear again, guys. This is a procedural dismissal. This is a procedural dismissal. Oh, Kurt just had a stream. I mean, if he wants to come on and talk, I would, but I know he's probably busy, or at least he already read through this and he's like, the one thing you want to do after you do a stream is redo it again. But you know what? He's out there. It's me. It's Edwin Meese. It's not Mice. It's Edwin Meese. You guys knew who Mark Levin is. He was the chief of staff for Edwin Meese when Edwin Meese was the attorney general. So this is not a procedural thing. I mean, this is not a substantive issue. Kind of like with Alec Baldwin, where there was a Brady violation and there were violations of the Constitution, and it was regarding pieces of evidence. I would argue that was a substantive dismissal and mistrial. This is here the judge saying, procedurally, the rules weren't followed properly and the proper rules weren't applied. So it's not dismissed with prejudice. It can always come back in this type of situation. And even if, let's say, she had said dismissed with prejudice and went bam right onto it, Jack Smith could appeal that to the 11th Circuit, and the 11th Circuit would say, actually, listen, Aileen, come on, Aileen, they can try this again, and it's not permanent. So they can correct the error. Falcon Hoof, yes. It sounds like there might be a way to, at least with the funding issue, the Jack Smith has said, well, then fine, I'll go talk to Attorney General Garland. He'll give me all the money I want. The DOJ can use its funding. And that's the neat thing, guys. Remember, there's Supreme Court cases that have talked about this. When Congress gives money to them, that's it. At that point, Congress has no more control. So Congress is given money, but the Republicans in the House can't go, wait. You're using it on a special counsel. Nope, can't do that. Once the money's in the DOJ's bank account, I mean, it's not really in their bank account, but they have authorization to draw funding. Once they've been given approval to withdraw funding, that's it. They can do it however they want. So they could give Jack Smith, hey, Jack, here's your $25 million. Go at it, kids. The Crease Man says the case is streamed with prejudice and will not be streamed again. Cat Mattis says, can he now smooth Jack Smith personally? No, because I think he could say he was operating in good faith, that he had prosecutorial immunity and was duly authorized to do this. So I don't think that would work. And I think Trump would be happy with just taking the dub right now and going home. Ultimately. So let's get back to... Actually, hold on here. What are we... Just making sure you guys... People sent me a bunch of stuff here. I want to make sure I didn't miss anything. Okay, no. We're all set. Okay, and then 2.0 just said, what is this here? Burgum and Rubio were told they're not Trump's VP picks. And I think Burgum may have been a kind of an interesting way of doing it. So, anyways, whatever. Let's get back to this chat. We're burning daylight. We are burning daylight. Oh, Bushmaster says, "Oh, you guys are talking about the song." Yes. Falcon says, "Is there a time scale on when another attempt can be brought to file charges against Trump?" I don't know. I don't know how long it would take the DOJ to recalibrate. I mean, to get the funding, I don't think it would take them very long to get more funding back in this. That's not an issue. Getting funding. Focus. Jeez. Wow, that was blurry. Jeez, my beard is like 2.0 probably said something I ignored about that. So, oops. Getting the funding is probably not the hardest part of all. I think that would take them very, very short amount of time to fix because it's internally within the DOJ. They've got money. They'll just quit. They'll subtract it from other things. They can cut corners at other places. That's not their big problem. I think a bigger problem is, let's say the 11th Circuit agreed with this, and let's say the Supreme Court was like, let's say they have their conference, and they're all the justices are sitting in a room, and Clarence Thomas is just sitting there, come walking in like Vince McMahon, and Sotomayor sitting there going like, they're like, "What do you think, Sonia?" She's like, I think Clarence is right. And Clarence will be like, "What's that? I can't hear you back here." And she'll go, "You're right. You're right." I think that's what she's gonna say. Hold on. I'm not talking about you. I'm saying Clarence Thomas was right. Oh, 2.0 can hear that. She's like, "Oh, you're talking about me." I'm like, "Not this time." But I think Kagan's gonna be like, she's also gonna be like, "Yes, Clarence, I think you're right." And Clarence gonna go, "Ha ha ha ha." I think that's what's gonna happen. And if that happens, then Biden has to figure out, how do I reappoint Jack Smith? How am I going to do it? Because is he going to get confirmed by the Senate? Nope. He would get confirmed by the Senate. Is there already congressional authorization to allow him to do it? Nope. Is Congress going to allow it to happen? Nope. So that's the bigger threat for Jack Smith, I think, at the end of the day here. I think that's the biggest threat. Oh, 50 Cent's going to show up to the GOP convention, maybe. That would be interesting. Sean needs some posters behind him like Salty Cracker got. I haven't seen what Salty Cracker has up in the studio, but you can't shout at her on her potentially craft channel. Oh, I could do what I want on this channel, chat. And Dr. Coffin Nail says, "Oh, hi, Sean." Yeah. So like I said, I think the big problem is going to be getting the appointment. Getting the money, that's easy. That's so, I guarantee you Garland's sitting there just like, "Fine, I'll cut you a check." But let's get back to this. And they talk about here, this is an interesting one. This is the Notre Dame Law Review article. And guys, if you ever see what law reviews, when they cite, this is how you'll see them. And it says why Robert Mueller's special appointment as special counsel was unlawful. Trump appears to agree with these arguments, although not explicitly in clear statement terms. And special counsel Smith seems to reject the imposition of any rule of construction or presumption. So there's a bit of an issue here. And she says, without purporting to survey the clear statement jurisprudence, that means the way things have been done before and just up to this point, is enough to say the clear statement rules have been applied as a substantive canons of construction in various contexts to produce foundational constitutional guarantees and usually to solve questions of ambiguity and statutory interpretation. And now she's citing, see Amy Comey Barrett, Substantial Canons and Faithful Agency, out of the Boston University Law Review. So yes, that ACB, yes. Yes, the lady holding up the blank notepad. Yes, Judge Amy Comey Barrett, Justice Amy Comey Barrett. And then she also cites a case of West Virginia versus the EPA, a 2022 case, where Justice Gorsuch is concurring. You guys can see what she's drawn from how she's setting this up. Mary Rose says, "What did my alma mater do?" Just they had a law review article she's citing. Just that would be good information there. Clear statement rules do not require Congress to use magic words or state its intent in any particular way, and that's true. But they do require Congress to speak clearly and not merely plausibly, as discerned through traditional tools of construction. Can you guys read this as I'm going, or is it washing out for you? Because I just realized this might be washing out as you guys are trying to read it. Is it too bright? Just real quick, chat. Looks fine. It's okay. I can't read. Well, that's impressive. You made that work. But yes, thank you. Fine, good. I just want to make sure. I didn't check earlier. Normally, I just lighten it up a hair anyway. There. So. And then there's MOAC Mail Holdings versus the Transform Holdco. That's got to be the Wall Street Silver name Holdco. Hold on for dear life, a 2023 case. When a clear statement rule does apply, it can mean that a court chooses a lesser, though still tenable, interpretation of the statute as a means to protect the significant constitutional values. And it says the hallmark of a true clear statement rule is where a court purports to depart from the best interpretation of the text. Doesn't mean it's the correct, there's only one correct way, but there's going to be ones that are better than others. Because there might be multiple correct answers, but one's better than the other. So you take a test and you do that. And I always hate that because that's not the way you should be doing a test. There should be one right answer and not one wrong answer. Or if you're going to act like real life, if you both pick a different right answer, it shouldn't be against you. There are reasons to believe the application of a clear line rule would apply to the interpretation of statutes affecting the separation of powers balance animating the clause. The clear statement rules, as noted, generally apply when the statute implicates historical or constitutionally grounded norms that we would not expect Congress to unsettle lightly. And a separation of powers norms ring strong here, where the special counsel's preferred interpretations would displace the Senate from its ordinary and longstanding role of confirming U.S. attorneys and give to the executive seemingly unchecked power to create offices for outside prosecutions beyond the scheme designated in 28 of the United States Code. That's 28 U.S.C. 505, 509, 515, from there. Additionally, there are indications in the language of the Appointments Clause itself, specifically its repeated reference to law, and Congress's determination of what it thinks proper for vesting purposes, that support requiring Congress to make its intent with known discernible clarity. And then there are cases specifically in the clause, particularly Edmund and Weiss, discussed later, where the Supreme Court has insisted on textual clarity in faced with ambiguous language. That happens. In any case, despite Okay, we're gonna have to giddy up and go here. In any case, despite the appeal of applying a clear statement rule in this constitutional setting, the court finds it necessary to do so when we reach the same conclusion in this order, regardless. Neither party presses hard for or against such a rule. The Supreme Court has not expressly addressed whether a clear statement rule applies in the context of appointments clause, and in any case, the court is satisfied that standard tools of statutory interpretation to discern whether this law was at issue creates and evinces a congressional intent to vest the appointment power of inferior officer, the Attorney General, as a special counsel suggests. So what happens from here? The statutory structure of the DOJ and the Attorney General's appointment authority. Well, the court's saying it's going to survey the structure of the DOJ. Now we've already talked about these here. There's 28 USC 501, and it contains various structural chapters. And more importantly, it's an executive department. Remember, the Attorney General is part of the cabinet. He's part of the executive branch. They are in charge of enforcing laws. For present purposes, the most important are Chapter 31 for the Attorney General, Chapter 33 for the Federal Bureau of Investigation, meaning, like at 28 USC 531 through 540, Chapter 35 for United States attorneys. 28 also includes chapters for United States Marshal Service, and then for United States trustees. And guys, remember, trustees are for bankruptcy proceedings and other things where the government gets involved to oversee and guys, I think I've mentioned this before with United States bankruptcy trustees. They're some of the most. Oh, Granville has been recused. About time. Good job, Fulton County. Hit the road, Earl. Hit the road, Earl. Get the hell out of that courtroom. Damn. Thank you for the super chat as well, Darcy. So these are bankruptcy trustees. And guys, we've talked about this before. Bankruptcy trustees are some of the most powerful people in the United States. The courts give them untold authority and power. Also, the now expired independent counsel. And guys, let me take this real quick. I need to be right back because court calling. Let me take this. I'll be right back. Hold on 1 second. All right, sorry about that, chat. The Greens are in charge now. Yeah. The lead attorney is going to fire up a 9-hour Doug stream. Hey, I don't blame him. That makes sense. Sorry, they just asked. I just got asked to be a guardian on a case, so on a children's service case here. I got to mark this down. And where's my notepad? Hold on. Nickerson in virtual present request. All right. I'll get to that today. Okay. Sorry about that, guys. My apologies, chat. No. A guardian on a children's services case, like a guardian ad litem is what I got asked to be. So we will do that. Oh, Trump is announcing today at 3. We'll step away real quick to cover that. I am so sorry, by the way, guys. YouTube is not my full-time gig. So when the full-time gig calls, I'm taking that. I'm not saying you guys do support me. I appreciate all the support and love and everything for you guys. But that stuff's not enough to keep the lights on. So just so you know. Children's service cases don't suck. I mean, the facts in them suck, but it's helping people get their families back together, get their lives together, and then making sure the kids are okay. Yeah. 3 p.m. I think it's probably hold on here. Yeah, what time is Trump? Sounds like it'll be 3 o'clock. We'll switch over somewhere. There should be somewhere on YouTube, but we'll worry about that right then. If you guys could tell me. Oh, you heard Trump was 3:30. Okay, well, if you guys find it right away, let me know because I'll go ahead and switch over to it. We're going to keep going from here. Trump did fire up a stream a while ago. Yeah. All right. So in Chapter 31, and also our biggest friends of all, the ATF. So Chapter 31 requires the president to appoint with the advice and consent of the Senate Attorney General, the head of the Department of Justice. The Congress then provides for the president appointment of various officers within the department, all expressly by with an advice of the Senate. These include a Deputy Attorney General, an Associate Attorney General, the Solicitor General. And the Solicitor General, guys, is the one who goes out and does the actual court stuff. So the Solicitor General argues in front of the Supreme Court primarily. That's their job. And 11 other Assistant Attorneys General that have to get confirmed by the Senate. In each of these statutes, Congress employs statutory language fully tracking the default matter of appointing principal officers. By contrast, in a separate section, Congress permits the Attorney General to appoint an Assistant Attorney General for administration. I mean, he's allowed to pick the guy who's in charge of running the day-to-day operations and running the internals and being the bureaucrat. That makes sense. That makes a ton of sense. Congress doesn't need to make that pick. A non-employee officer who Congress expressly places in the competitive service. I got discovery on that case. Hell yeah. Yeah, oh yeah. Oh yeah, I was waiting on that. That's going to be good. Chapter 33 governs the FBI. It should be one sentence. The FBI is hereby disbanded. It's headed for a term. The FBI director is appointed for a term of 10 years, who is paid under the federal executive salary structure. Chapter 33 also authorizes the Attorney General within his control of the FBI, and as discussed in later connections, remember, the FBI director is not a cabinet official. He is subservient in the DOJ, but he has his own authority. Okay, so it looks like it'll come. Trump's going to do it around 4:30. All right. All right. So God, it's just been a bit, guys. The past couple of weeks are just bangers of information and news to cover. And we'll cover the YSL thing probably after we get this done. 2093. We got to hop on our horse and go. Chapter 33 also authorized the Attorney General within his control of the FBI to appoint officials to detect and prosecute crimes against the United States, assist in the protection of the President and the Attorney General, conduct investigations regarding official matters. Chapter 35 relates to United States attorneys and directs the President in mandatory terms appoint, with the advice and consent of the Senate, United States attorney for each judicial district. So there's 93 judicial districts. There's 93 U.S. attorneys. U.S. attorneys shall be appointed for a term of 4 years, and they're subject to removal by the President. The President can hire and fire them as he sees. The Senate can appoint him. The Senate can say, yep, we agree. He can make him. So like the Attorney General or the U.S. Attorney for the Northern District of Ohio, Biden can appoint one. The Senate can confirm him. And then Biden can say, you know what? You're fired. You're fired. You're fired. Like Vince McMahon. Fire him out and get rid of him. All 93 current U.S. attorneys have been appointed by the President, confirmed by the Senate. Except Congress has permitted the Attorney General to appoint interim U.S. attorneys with specific restrictions. So if one quits or dies, or there isn't one ready to go yet, there's a limiting duration of terms. They can also appoint attorneys to assist United States attorneys when the public interest so requires, including the appointment of tribal prosecutors. Now, guys, that's another thing here. There's always what you can do under U.S. law, but then there's like an exception for Indians. So tribal prosecutors, they're allowed to bring in people from the attorneys with tribal affiliation to help them prosecute things, because the U.S. Attorney's Office for that district is the one responsible for prosecuting federal crimes that occur on tribal land. The tribe may have their own courts, sure, but if you commit, like if you do bank robbery on a reservation, you're getting prosecuted by the United States attorneys in that district, but they may bring in tribal help. Yes, guys, I'm talking about the Native Americans. So, as it gets further, Jack Smith does not rely on 28 U.S.C. 543. And it says further, special attorneys are subject to removal by the Attorney General. Noting he isn't and he's not assisting a United States attorney. And that's true. He's not assisting a United States attorney. He's not assisting a United States attorney for the Southern District of Florida, or the one that's in the District of Columbia. He's operating under his own thing. And currently, the Southern District of Florida, the Southern District of Florida attorney is this guy, Mackenzie LaPointe. This is the United States attorney for the Southern District of Florida. So he was nominated by Biden, and he's been there. He's been around, and he is here. He doesn't look that old, but he was in the Gulf War. Jeez. Black don't crack. It's like keep finding out that's true. That's true. It's a true fact. So here we go. But he's never worked with that guy. He's never worked with him or under him or assisting him. I don't think there's too many pictures of Jack Smith and these guys like shaking hands, broing out, working in a doc session together. Nothing. So that is a Tico Love arc. Stop. Jesus Christ. There's one last piece of United States Code in which the Attorney General is given appointment authority, and it's in 18 U.S.C. 4041. That section, located within the prisons and prisoner part of Title 18, passed in 1948, authorized the Attorney General to appoint the Director of the U.S. Bureau of Prisons, who serves directly under the Attorney General and also permits the Attorney General to appoint such additional officers and employees. So, yes, he's allowed to appoint the head of the Bureau of Prisons, which supervises federal corrections. So like Florence Supermax, the ADX, they are down there. Or if you live near any sort of FCI, Federal Corrections Institution, or near a labor camp, anything like that, those are supervised by the DOJ. They're overseen by the DOJ. There are no other provisions of the United States Code of which the court is aware that permit the Attorney General to appoint officers and employees. Now she's going to... Triptych is saying J.D. Vance left his home in a motorcade. Yes, but guys, remember, after the attack on Trump, everybody, like, security's been beefed up for everyone. Everyone's become a hardened target. I really don't think it's J.D. Vance. God, that makes... Now we've got two guys at risk for Senate, and both Senate seats in Ohio are at risk. Because I don't think Sherrod Brown's going to lose here. Shill's hard enough for the union. Just saying, I don't like that idea. Anyway, now we're gonna evaluate the four statutes: 509, 510, 515, and 533. The court concludes none vest the Attorney General the appointment authority to appoint a special counsel, because he doesn't assist the U.S. Attorney, but he replaces the role of the United States Attorney within his jurisdiction, and he entirely does. Jack Smith went to the grand jury on his own. Jack Smith has been handling all the stuff. Jack Smith got the search warrant. That's the U.S. Attorney's job. And she's saying, bam! In considering these four provisions, court begins where all such inquiries begin, within the statute itself. This court requires the court to interpret statutory language according to its ordinary meaning, and to read within the specific context of which it appears and within the broader context of the statute as a whole. So they point out the whole text canon refers to the principle a judicial interpreter should consider the entire text in view of its structure and physical and logical relation of its many parts. So 28 U.S.C. 509. It's functions of the Attorney General. And it says the functions, all functions of other officers of the DOJ and all functions of agency employees of the DOJ are vested in the Attorney General. And this is where, like, assistant U.S. attorneys. So while the United States Attorney for the Southern District of Florida, this guy, Marquenzi LaPointe, is appointed by President Biden, all the other United States attorneys that work in that office are civil service employees. They apply and they get a job and they get hired. Joe Biden cannot have him fired. Now, yes, Joe Biden could have put pressure on Marquenzi LaPointe, like, you are serving in the DOJ, and I'm sure the Attorney General could fire you, but you're not able to be dismissed on a whim. It's not as easy. Okay? So, except vested by subchapter 2 of Chapter 5 of Title 5 and administrative law judges employed by the DOJ. And there are some administrative law judges employed by the DOJ. He doesn't have authority over them. The functions of the Federal Prisons Industries Incorporated, which, yes, there are for-profit things there, and there are corporations involving the prison industry. And the Board of Directors and Officers of Federal Prison Industries Incorporated, which I've heard of them before, and it is a federal agency. Federal Prison Industries is let me see if I can bring it up here. It is in charge of the reentry and job training for the United States government and the federal prison system. When you work at some of the federal prison industries, the federal government may make things while inmates are in prison. Well, they're sold. And Unicor is the organization in charge of doing that. So this is a real thing. I shit you not. So this isn't a private prison, Vodka. I'm talking about, so like if you're at, let's say you're at ADX Florence, okay? You're at Supermax. They might have a furniture factory there where part of your job is you learn woodworking. So you have a skill when you're getting out. Obviously, you're not getting out if you're at Supermax. Or some of these places may have you manufacture goods and services. For example, in Ohio, one of the prison industries, they make state of Ohio flags that gets sold, and the state of Ohio uses them everywhere. But also, governments could buy flags from them. You know, there's all kinds of things you can do. So those have to be sold. Well, the Bureau of Prisons can't do it. They set up the federal prison corporation to do it. Yeah, your Foot Locker and boot camp could be made by prison industries. So it's still a bit of a racket, but this is not necessarily for-profit prisons. This is a separate matter. Just so you understand. Getting back to this, Smith Knight argues 509 establishes any office, nor that it grants officer reporting power to the Attorney General. And she says it does neither. All it does is in limited instances of things that he can't do. She says no more discussion is necessary because we agree it doesn't matter. 510 says the Attorney General is allowed to delegate his functions to officers, employees, and agencies of the DOJ. He can delegate his authority. He may, time to time, make provisions authorizing the performance by any officer or agency of the DOJ with any function of his. And basically, he's allowed to make somebody say, you're doing my thing for me. Kind of like a judge as a magistrate. You are my guy right now. Smith does not classify or rely on Section 510. Similarly, the phrasing in Section 509, 510 merely gives the Attorney General flexibility to authorize existing DOJ officers, employees, or agencies to perform his functions. Jack Smith, as all agree and are required by the extant Special Counsel regulations, was selected from outside the United States government. So he's kind of fucking himself there. Well, I can't use this because I'm not part of the government. 515. The third statute cited is authority for the legal proceedings. Commissions, oaths, and salaries for special attorneys. The attorney or any attorney specially appointed by the Attorney General under law may, when directed by the Attorney General, conduct any kind of legal proceeding, civil or criminal, including grand jury proceedings. They are authorized by law to conduct, whether or not he or she is a resident of the district in which the proceeding is being brought. So that doesn't really change a lot there. They're saying each attorney, does that help Jack Smith? No, it's just saying he doesn't have to live there. Each attorney specifically retained under authority of the DOJ shall be commissioned as a special assistant to the Attorney General or special attorney and shall take the oath required by law. Foreign counsel employed in special cases are not required to take the oath. The Attorney General shall fix the annual salary of a special assistant or special attorney. Although they're saying Jack Smith primarily relies on this, we'll analyze each part of it. She says Part A does not authorize the creation of an office, nor does it say the Attorney General could appoint anyone. Nor does Jack Smith meaningfully argue it does. It just declares the Attorney General, any officer of the DOJ, or any attorney specifically appointed, regardless of whether or not they reside in the district, okay? This is a provision conferring territorial flexibility to the Attorney General, meaning there's no limit to where you have to live. He can bring in people from out of town. It permits the Attorney General to use DOJ officers or previously appointed special attorneys to litigate on behalf of the United States regardless of residency. And that's the thing. So, like DOJ lawyers from Washington could come out to Nebraska. Jack Smith, if he was properly appointed, could go wherever he wants. And she's saying no more can be inferred from this because it doesn't meaningfully rely on officer appointing power. And I agree. Pretty simple. 515B, where Jack Smith is really making more attention because it talks about getting paid, says there's special attorney appointment authority here. Where are you guys? Hold on here. Who just messaged me? Okay, we're gonna keep going. We're gonna keep going here, chat. 470. Oh, geez, people are just leaving. I guess it's not that interesting, huh, chat? This is so he contends because this is specifically retained under the authority of the Department of Justice. He's saying that necessarily means specially retained by the Attorney General as head of the DOJ and vested with all its powers. And then there's two, the terms commissioned and specially retained in the statute effectively mean appoint. So she's going to go to the ordinary meaning. And she says it's a logistics-oriented statute that gives technical and procedural content to the position of already retained special attorneys or assistants within the DOJ. It says those attorneys, again, already retained in the past tense. Hi, 2.0. She just logged in. I'm making sure I don't know. Everything okay, sweetheart? I don't know if she's listening. All right. And shall be commissioned that is designated or entrusted tasks to assist in litigation. It then provides those already retained attorneys or special assistants must take an oath, and then it directs the Attorney General to give them a salary. So, yes, it's a logistical thing. Okay, if you have them, what do you have to do with them? They have to take an oath, and you have to give them a salary. Okay. It's not saying he could do it in this chapter. It's already saying it's happened. Understanding Section 515 as a descriptive statute about already retained attorneys. And you know what? I'm actually starting to agree with Judge Cannon here. That makes sense. And I don't know if Kurt and Nate would disagree with me there. But it's not saying you can do it. Remember, you are limited by what's in that statute. That statute says X. Well, that's what we're talking about. And you could imply or infer, well, there's got to be a point where he can appoint people. But all it's saying here is if anybody gets appointed and confirmed by the Senate and you have a valid appointment, you have to make sure they take an oath as the Attorney General. You have to make sure get this guy's oath down, unless he's foreign. And then second, you got to pay him. You set the pay rate. Now, that also means he can't set the pay rate at like $1 million a year. That would be, he could, but I don't think that would go very well. She then did say first as a district court in a case called Concord Management and Consulting observed in evaluating a similar challenge, and as alluded to above. Trump shows JD Vance. Oh my God. Is that live right now? We'll see if it's live chat. Oh, geez. All right, let me see here. All right, hold on. God, we're so, ugh! We're making this tough. We are making this tough out there. All right, guys, so we don't know yet Oh, here we go. Or is this it?
It's
Or...
the honor of my life on behalf of my great state, the Hoosier State,
Oh.
to cast all 58 votes.
Oh, wait, never mind. They're not.
Greatest president of my lifetime and my friend,
Oh.
Donald.
Yeah, they're talking about doing it now. Yeah, JD Vance confirmed. It's like, that's gonna make Ohio Senate things tougher now. Huh. Damn it. Kurt disagrees with me on this. He thinks it's all the power rests of the AG. It gives him the power to appoint Smith. Well, it gives him all the. I would argue it sounds like Judge Cannon saying it gives you all the power to govern him and run him. You don't get to hire him. So it's, yeah. It's kind of like the U.S. attorneys. The DOJ has a lot of authority over the U.S. attorneys, funding them and doing all kinds of stuff. He can't hire or fire. So I think that's a very big thing there. So that is where we are. So let me move this back out of the way. Well, yes, Ohio's governor appoints the senator for a vacancy, but I'm worried like he is a good, reliable, being able to retain the seat. If we then end up with a rum dum who loses the election, that's not good. Oh, Trump made his announcement on Twitter. Oh, okay. I guess that's the way we're doing it now. I guess that's the way we're doing it. Real Trump. Let's see. Yeah, here we go. Here we go, chat. After lengthy deliberation and thought, and considering the trends, talents of others, I've decided the person best suited to is United States Senator J.D. Vance of the great state of Ohio. Whoop. Served our country in the Marine Corps, graduated from the Ohio State University in 2 years. That should tell you a lot. People at Ohio State are stupid. Summa cum laude is a Yale Law School graduate, or he's editor of the Yale Law Journal, and president of the Yale Veterans Association. JD's book, Hillbilly Elegy, became a major bestseller and championed the hardworking men and women of our country. JD has a successful career in technology and finance. And during the campaign, yeah. I mean, I think that this is Trump's way of trying to lock down Pennsylvania and Wisconsin and maybe get Minnesota for the first time since Reagan. Who knows? Who knows? Who knows? We'll see. Who knows? We'll see. So, yeah. He used to be an ever-Trumper, too. That's the interesting thing as well. It's very interesting in that regard. The great state of Ohio. It is a great state. It is not the Ohio State University. No. It is just an Ohio State University. It is not the Ohio State University. Definitely going for the Rust Belt votes. Yeah. Yeah, I mean, if he locks down Wisconsin and Pennsylvania, it's probably a lock. So, and also Michigan. Indiana's like, Ohio is okay, I guess. Nobody likes Indiana. So anyways, we're going to keep going here. We're going to keep going, chat. So the Congress, and they say that Congress's uses of a verb tense can be significant in evaluating statutes. True. And so here, the same thing is going on. It doesn't allow anybody the active power to retain anyone afresh, but simply notes requirements for people specially retained in the past under the authority of the DOJ. Second, absent is any reference to the verb appoint, an active verb. To justify that void, special counsel says the court should read the terms specially retained and commissioned as the functional equivalent of appoint, and I don't think that's actually a stretch. The court declines to engage in such linguistic distortion It's not really that big a distortion. Nor is aware of any vesting statute that uses those verbs as replacements for the verb appoint. For starters, the term appoint on the one hand and terms retain or commission on the other are not invariably interchangeable. When they say when a statute does not define a term, we often look to dictionary definitions for guidance. Definitions of appoint describe the filling of a more enduring and often formal role or office. And they talk about this, and they talk about in Merriam-Webster's Collegiate Dictionary to name someone officially, the Oxford American Dictionary to sign a job or a role. This differs from retain and commission, which often connote a narrower mission or task-specific hiring or charge. And retain in Webster's third definition says to keep in one's pay or in one's services, like people would retain an attorney. Like here, a lawyer. Or commission is to endow with effective right or power for a certain task, mission, or duty. Like military officers are appointed. Military officers are commissioned. And they're commissioned to fill a certain task, mission, or function. Doing military stuff. In any case, even accepting some degree of overlap, it remains a case the Supreme Court has been apprehensive to accept other statutory terms as stand-ins for the word appoint in the Appointments Clause context. And that Congress uses the word appoint rather than the terms not found within the Appointments Clause. Moreover, total mass retain. So we keep going, and the judge keeps hammering here. Moreover, the same verb tense stated above, whenever the linguistic overlap might exist between the present formulations of appoint, retain, or commission. Section 515 doesn't use them in that format and doesn't use them interchangeably, instead using the past participle adjective application. All of this yields the following terms of ordinary meaning for the terms specially retained and commissioned as special attorney. Retained essentially means employed or hired. Commission means designated, classified, or tasked in a role. And together, those phrases transmit the fairly mundane descriptive point that already hired attorneys within the DOJ shall be classified as assistants or special attorneys and shall take an oath and have a fixed salary. That is all that can be fairly extracted from Section 515B. There is no granting of appointment power in this language. Nor, as the special counsel suggests, is the historical pedigree of presidential commissions dating back to Marbury versus Madison transform the adjective phrase shall be commissioned as special attorney into an implicit grant of officer appointment power for the attorney general. It says, true as Marbury informs, the last act to be done by the president in making an appointment for constitutional officer is the signature of commission, thus demonstrating an action on the advice and consent of the Senate to his own nomination. But nothing in the language of Section 515 speaks in terms of a traditional presidential appointment, was set at confirmation followed by the signing of an officer-level commission, as was the case in Marbury. And they're saying far from it. Simply put, whatever historical relevance there is to take from the fact that presidents, not attorney generals, sign commissions for constitutional officers, it does nothing to alter the ordinary meaning. Now, she does talk about the statutory context of everything. And there, I hope that makes sense to you guys. I hope that makes sense. I hope this all makes sense to you guys in a way that you can understand this. She's saying that ultimately Jack Smith has not been properly appointed here. And the things he relied on don't really count. And it does not allow her to go forward from there. Now, that's where she's going to lay down the boom, and this is where she's going to demolish his ability to be in control of things. And we are We'll get to the parts about United States v. Nixon, because I do think that gives us something to skip ahead and look to here, because it does talk about the issues that occurred there and addressing that as an argument. All right, where is this? I just passed it. All right. So just popped in. So Cannon dismissed. Yes. Once again, it's a procedural dismissal saying Jack Smith didn't have the right to bring it. He wasn't properly appointed, but it could be rebrought. She's not dismissed as with prejudice. And that's just ultimately like it could come back. It's not gone forever. So we are. Where did I just have it? There we go. Who's messaging me? All right. So we're going to move back to this. Here. So this is United States v. Nixon, and this is the analysis using US v. Nixon. So the parties disagree about the precedential value of a passage from US v. Nixon. That passage is below. Here the court emphasizes the statement that serves the focal point of the parties' dispute. And it's been italicized here, but we'll get to this. Under the authority of Article 2, Section 2, Congress has vested in the Attorney General the power to conduct the criminal investigations of the United States government. And that's also in 28 U.S.C. 516. It is also vested in him the power to appoint subordinate officers to assist him in the discharge of his duties. And that's, remember, 28 U.S.C. 509, 510, 515, and 533. Those are the ones, not the rest of them. There wasn't extra ones. There wasn't a, hey, here's a table, hold this box. Don't ask questions. Anyways, acting pursuant to those statutes, the Attorney General has delegated the authority to represent the U.S. in these particular matters to a special prosecutor with unique authority and tenure. The regulation gives the special prosecutor explicit power to contest the invocation of executive privilege in the process of seeking evidence deemed relevant to the performance of these specially designated duties. So she added emphasis. See, says the defendants argue, and that's Trump and his people, are arguing the Nixon statement about the Attorney General's statutory authority is non-binding dictum. Remember, dicta is merely somebody, in their opinion, talking about something, and generally, because it's a holding, it's non-binding, meaning this is in the victorious part of the discussion. This is in the ruling, not the dissent. The dissent is always dicta because it's not winning and controlling. But you can have non-controlling parts of the winning opinion. And they're saying it should not control the statutory analysis. The special counsel argues that this is true and it formed a necessary element of the Nixon holding. He's saying, nah, he's saying it's critical. It's not dicta. He's saying it's for real. It's critical to the case. And therefore, it's binding precedent. Following a comprehensive review of the record, the court concludes that the disputed statement from Nixon is dicta. And they point out the issue, the Attorney General's appointment authority was not raised, briefed, argued, or disputed before the Nixon court. And that's important. It's very, 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 very important. Because they're saying it didn't matter. Because they didn't talk about it during the case. And because they didn't talk about it as part of the statements that were raised, briefed, argued, or disputed, any court discussion about it is dicta. And ultimately, courts should only discuss what's been raised, briefed, or argued, or being disputed before them. If they go off on tangents, that's not helpful. because then they're prejudging other cases. So, Judge Cannon says Nixon undoubtedly precedential in several areas. For example, its pronouncements on the justiciability of an interbranch controversy, the test for issuing Rule 17 subpoenas, and the application of executive privilege in the face of a valid subpoena. Those issues were presented, argued, and carefully considered. The same is not true of the Attorney General's statutory appointment authority. At most, Nixon assumed that anteceded position without deciding it. Thus, Nixon's passing remarks on that point are not binding. On precedent future cases, as here, that directly raised the question. Given these remarks, precedential rate runs a risk that stray language from Nixon's opinion will take on importance in a new context this drafter couldn't have anticipated. That's something you have to think of, like, why is this being done this way? She says that section contains 4 parts. The court reviews the holding dicta discussion, provides context, analyzes the disputed passage, and discusses its proper application. So she starts out with the standards. Not all text within a judicial decision serves as precedent. And that's true. That is 100% true. And as I said, guys, again, Brian Gardner, he is he's a law school professor and is like a legal writing guru. And it's important to distinguish between holdings and non-binding dicta. A holding compromises both the result of the case and those portions of the opinion necessary for that result. Dicta, on the other hand, is a statement that neither constitutes the holding nor arises from a part of the opinion that is necessary to the holding. So you can concur, and you still have dicta in it, because clearly it's necessary to a holding. Because you might have, I concur with part A, but not part B. We see that all the time in these cases. Concurring partly, dissenting in part, or concurring in part, and then pulling a Clarence Thomas and walking away. You could do that. Well, the courts must dutifully follow presidential holdings. Dicta is not binding on anyone for any purpose, and that's true. Dicta is never binding, but you can use it. Statements and opinion that extend beyond the scope of the issue presented, briefed, and argued generally constitute dicta. Questions that lurk on the record, neither brought to the attention of the court nor ruled upon, are not to be considered as having decided, so as to constitute precedents. The effect of the omission was there not raised in briefs or arguments, nor discussed in the position of the court. Therefore, the case is not a binding precedent on this point. Then they point out the same is generally true of assumptions that are not peripheral to the issues presented. That there's often grants a certiorari to decide particular legal issues without deciding the validity of antecedent propositions. Such assumptions, even on judicial grounds, are not binding in future cases that directly raise the questions. And they point out these assumptions, whether implicit or explicit, aren't generally considered precedential. And they're saying it is a maxim to not, and this is done by Chief Justice John Marshall, not Thurgood Marshall, John Marshall. Chief Justice John Marshall is one of the OGs of the Supreme Court. So, he was the 4th Chief Justice of the United States Supreme Court. He remains the longest serving Chief Justice. He was around forever. That little voice says, how about nothing about dicta mouth? No. There's nothing about dicta mouth. No. Saying it's a maxim that is not to be disregarded. that expressions in every opinion are to be taken in the context in which they're expressed. Well, and you have to just base that there. If they go beyond the case, they may be respected, but ought not to control the judgment in a subsequent suit. The reason for the maxim is obvious. The question actually before the court is investigated with care considered in its full extent. Other principles which may serve to illustrate it are considered other principles may serve to illustrate it are considered in the relation to the case cited and their possible bearing on all other cases is seldom completely investigated. Lastly, not all dicta are created equal. Dicta for the Supreme Court is entitled to considerably more presidential weight than other dicta. It's a dicta competition out there. Decisional context. This is where she keeps talking about the issues surrounding dicta and what's important there. Ow. So as she keeps going here, she keeps weighing these issues. And she keeps on addressing the problems here. And this second part, the decisional context, is not really that I don't think this is actually very difficult to understand here. So Nixon involved the special prosecutor Leon Jaworski's investigation and prosecution of those involved in the Watergate scandal, like G. Gordon Liddy, H.R. Haldeman, etc., etc., etc. The special prosecutor issued a subpoena to Nixon, an indicted co-conspirator, requiring the production of certain tapes and documents relevant to the investigation. I mean, yes, and these are the ones that Nixon referred to turn over. The special prosecutor did it requiring the production of certain tapes and documents in the investigation. Nixon moved to quash it, raising three principal arguments. First, Nixon argued the courts are without the authority to rule in the scope or ability of privilege. That turned out to be incorrect. The circuit court found this to be foreclosed by circuit precedent. Second, and most important, was the issue here is that the interbranch dispute presented a non-justiciable question. Referencing the appointing regulation which carried the force of law, the district court found that the special prosecutor possessed sufficient independence to create a justiciable controversy. And then Nixon argued that the issuance of a subpoena had not been satisfied in asserting a confidentiality privilege. The lower court disagreed. And they also point out none of these arguments had anything to do with statutory appointment of a salary or the appointment authority, the appointments clause more generally. Geez, I had one thing. Addicted to cocaine. So at the Supreme Court, Nixon re-raised the same challenges. On the justiciability question, like Nixon re-raised the same questions. The court rejected the argument that's a non-political question. In doing so, however, the court offered a prefatory paragraph to contextualize the nature of the proceeding for which evidence is sought. The relevant portion of that paragraph was also reproduced above. Following the stage-setting paragraph, the Supreme Court determined that the extent regulations delegation of authority, both the independence it created in the special prosecutor Jaworski, and the limitations it placed on his removal, establish a justiciable case or controversy. They talk about, in light of the uniqueness of the setting in which the conflict arises, the fact that both parties are officers of the executive branch cannot be viewed as a barrier to justiciability. mean, and that does make a lot. I do think it's interesting they had to write that because they're like, well, wait, the fact that they're part of it, they're the same. They're both part of the executive branch, and we can't do anything about it. It's like, nope, you're allowed to do something about that. With this in mind, the court, she's referring to herself, proceeds to analyze the disputed statement. Let me see here. Just checking in real quick. Some of these super chats. Sleazy gets 5 memberships. Thank you, Sleazy. JB05 says, how untold DeWine puts that Cuck Matt Dolan as JD Vance replacement. Well, if he does that, then who's going to win the race? Because remember, Ohio Senate's up for a race. So, like, Sherrod Brown's going to win it. I don't want that. So, I'm just saying, like, we're screwed in Ohio. This isn't good. It's going to be very weird. DeadTube, you sent me a screenshot of Trump's announcement. Yes, I do. I have it. Thank you very much. Rocky's been a member 2 months as Judge Glanville's been removed from the YSL trial. Yep. We'll be covering that later. And Germ70 says, missed out on the best VP pick that could have been done. Robert Barnes. He will get Coke legalized only for Ricada. Better call Barnes. Always bet on Barnes. Unhung Hero says, oh, I'm going to come. Keep moving, Grace. So the Attorney General's appointment authority is not an issue before the Supreme Court in Nixon, and that's true. Certiorari was granted in Nixon to cite 6 questions. 1, whether the president has assumed the sole personal and physical control over evidence, demonstrable material to the child charges, and it's about whether he can, evidence demonstrable material to the trial charges of obstruction. Here, and then this is obviously one we don't need. It says, whether a federal court's bound by the assertion of an absolute executive privilege. Okay, well, don't need 1, don't need 2. Whether the claim is executive privilege. Okay, we don't need this one. And then it says, whether the claim is executive privilege that otherwise might have been applicable to discussions in the offices the president was in. And he's concerning those about Watergate. Maybe waive our previous testimony pursuant to the president's approval and by the president's public release of a bunch of pages of edited transcripts. And that's another argument we don't need. Finally, whether the district court properly concluded that a subpoena duces tecum issued to the president satisfies the Rule 17 of the federal rules. Nothing about special counsel being elected. In Nixon's corner, they made a question whether under the Constitution a grand jury has the authority to charge. And it's whether or not they have the authority to charge an indictment. And to charge an unindicted co-conspirator in a criminal proceeding. So these questions actually before the court were investigated with care, and they were considered their fullest. None of it talks about how do you appoint a special counsel. So the Attorney General's appointment authority was never discussed. Because statutory authority question was not before the Supreme Court, the opinion single prefatory sentence does not amount to a presidential holding. And guys, I'll be right back. Give me 1 second. All right, guys, we're back. Sorry. We're all set. So, the special prosecutor's validity was uncontested. And this is something here where a case is not binding precedent on points that were not raised in briefs or arguments nor discussed in the opinion. And that makes sense. If it's not in the opinion, how does it have any binding precedent on a topic? If there's a case involving the rules of civil procedure, how does that apply to agency interpretation? It won't. If it's not in the opinion, it's not binding precedent on other topics. And that's an easy one to get. We all agree. Well, the point is with Nixon, there's no talking about it. It just touches on the subject for a second. They say where the issue in the passage was not presented as an issue and hence not refined by the fires of adversary presentation, it's far less likely to constitute a carefully crafted and reasoned essential part of the court's opinion. So they're citing cases out of the Seventh Circuit and they're using Judge Posner, which I think he got a little TDS at him overall, but he's still a really very well written judge. When you open up law books in law school, a bunch of them are written by Judge Posner, appellate opinions. Him and Judge Learned Hand, are all over the place. All over the place. No, I'm not a senator. I didn't get a call from the governor. That was not what that was all about. Yeah, hold on. Wait, yeah, Governor DeWine. Not gonna lie, if I got a phone call from him, I'd be like, hold on here. What is this? Well, apparently Elon's doing some crazy stuff too. So, across 100 pages of briefing and hours of oral arguments in Nixon, neither party challenged the special prosecutor's validity or the attorney general's appointment authority. In fact, Nixon did not contest the points. And they say the president does not challenge the powers that were given the special prosecutor in the Watergate-related matters. And they say, we do not contest the special prosecutor's assertion that his authority is derived. And they say the special counsel acknowledges as much, saying that President Nixon did not contest it. And hold on, chat. I do need to take this. I don't know who this is, but let me take this real quick, chat. Hold on. All right, guys. No, sorry. That was actually, I'm glad I picked up. That was somebody had changed their number and I really need to get a hold of them. Okay. So the court statements on the Attorney General's statutory authority were not necessary to its resolution. Jack Smith is claiming, though, the comments of Nixon formed a necessary element of the holding. But it's not something anybody argued or agreed to or were arguing about. And she's saying this reads too much into too little. The disputed page is located within a prefatory stage-setting paragraph which merely served to tee up the case or controversy analysis that followed. As a recap, Nixon argued the case presented a non-justiciable political question by virtue of the interbranch nature of the dispute. The Nixon court disagreed. Justiciability does not depend on a surface inquiry. They said instead in the Nixon, they stated that courts must look behind names that symbolize the party to determine whether a case or controversy is presented. And they said in doing so, Nixon, they zoomed out, provided a high-level background paragraph explaining how the case landed Supreme Court. The starting point is the nature, and they talk about our starting point's the nature of the proceeding for which the evidence sought. It's within this overview paragraph that the disputed dictum is located. So it's them just breaking down how we got here. And they say Nixon's remark in the Attorney General authority is more akin to like an aside-like statement or digression. And more than that, rather than a matter of law pivotal to its decision. Kind of get it. They said determining in Larry case factory statement about a statute's operation was dictum because it wasn't germane to resolving the issues presented. Well, I mean, is it dictum there? And I think it would be. I think it would. I think it makes sense there. And they say to be sure, President Nixon delegated special prosecutor via the regulation power to determine whether or not to contest the assertion of executive privilege or any other testimonial privilege. And they wanted to know whether that was integral to his non-justiciable holding. And they say, in other words, two features were essential to the justiciability of the holding. One, the nature of the parties' relationship is defined by the very broad delegation of authority in the regulation. And two, the fact the regulation had not been revoked. And that's where they're saying, look, there is a difference here. But here's the difference. They say, but Nixon's passing reference to the authority was not essential to the analysis, and nothing in the remainder decision suggests the Supreme Court was reasoning from its earlier passing. Remarks. They say, having determined that it's dictum, the court considers appropriate weight to accord it. In this circuit, the Supreme Court dictum, which is well thought out, thoroughly reasoned and attached articulately, is due near precedential weight. Additionally, courts are bound by Supreme Court dictum where it is of recent vintage and not enfeebled by any subsequent statement. She says neither is the dictum thoroughly reasoned or of recent vintage. It doesn't engage any statutory analysis. Okay. And this is where we get things. Remember, in the Trump v. United States opinion, the immunity opinion, Clarence Thomas had referenced things. And yes, this is where Judge Cannon, and a lot of people said this is Justice Thomas saying, hey guys, if you want to fuck things up and go after Jack Smith, here's a good place to do it. And Judge Cannon looked at it and goes, yes, all right. And she's like, I'll take some notes and use this later. So she's like, Clarence Thomas is like, this is a special tool that'll help us later. Benjamin Lewis, member of 6 months, says, many men wish death upon me, blood in my eye, dog, and I can't see. Yep. Yep, if 50 Cent comes out at the RNC, that'd be hilarious. Germ for $2 says lawyer man PPP for the Senate. Yes. Mystery Sniper says Judge Glanville's off the case. Yes, we are aware and we'll be covering that later. I'm going to get a hold of Kat Williams. I know she's already on right now, but in case she's interested later. And I might tread around some people up. Ooh. I was going to open the window because I see the breeze and it is like hot as hell out there. Like really hot, like caliente. The Sky's a Neighborhood for £2 sterling. The King Sterling says, congratulations, the incoming Senate law blogger. Well, I am old enough. I don't know if I can accept foreign donations at that point, so you have to be careful. Yes, and that's the thing. 50 Cent performed the other night with Trump Photoshop behind him. Content Lasagna says Star Wars girl told me you were going to accept the Senate nomination. Okay, that I'm not talking about that, guys, as it's not worth bringing up. But that was actually fucking hilarious. That was hilarious. She didn't call me. Task. The power to appoint subordinate officers to assist him in the charging of his duties. Indeed, the extent of the next discussion comes in a single sentence. Congress vests in the Attorney General the power to appoint subordinate officers. No more was provided, only one sentence. They say, thus giving Nixon's dictum near presidential weight in solving the motion, which calls for a thorough analysis of the text, runs the risk the Supreme Court's language will take on importance in a new context its drafters could not have anticipated. So they bring up some other issues, though. Nixon was decided in 1974. In the subsequent half century, the Supreme Court has placed a renewed emphasis on structural principles underpinning the Appointments Clause, like Buckley v. Vallejo. Although you could argue, well, since then, 1976. They've had Freytag, Edmund, Weiss, Arthurix. And they say these post-Nixon developments in Appointments Clause jurisprudence and the Supreme Court's corresponding emphasis on structural principles lessen the force disputed dictum. So the issue here is, well, we've had a lot of discussion in the meantime. The jurisprudence and the mindset of the Supreme Court has changed. That's a pretty good argument. And then finally, they're out-of-circuit cases that have been cited. Remember, things not from your jurisdiction or a jurisdiction that's binding on you are just merely persuasive. So Jack Smith cites 2 out-of-circuit appellate cases in support of his position. The court and she says, like Nixon, neither engaged with the statutes put forth. The first one is the case In Re Sealed Case. In Re Sealed Case. In the matter of the sealed case from 1987, which was a challenge to independent counsel Lawrence Walsh's prosecution of the Iran-Contra scandal. Guys, remember Colonel Oliver North? That is where Iran-Contra came into being. And it was very funny because it was a hell of a scandal. It did not bring down Reagan, but oh boy, it was rough. It was rough. What happened at the time? Well, in the 1980s, after we had gotten our hostages back, we sold guns to Iran. We then turned around and gave that money to the Contras, which were the anti-communist guerrillas in Nicaragua, who ended up losing to the Sandinistas, who were the commies down in Nicaragua. And the Sandinistas, well, Sandinistas are in charge. And if you guys do know, the president of Nicaragua is His Excellency Daniel Ortega, the head of the Sandinistas, who was president for nearly 10 years throughout the 80s, and then has been president for the past, what has it been like, 15, 16 years in Nicaragua. So that entire thing there. It also, there was a lot of CIA money flowing around, and obviously a lot of things happened there, including a flood of la cocaína started flowing into the U.S. as a result of all of this as well. So as authority, and they were they got through things here, and as the D.C. Circuit Court kept going, the Attorney General cited a couple different statutes here to show he has the authority. And they said that despite expressly stating these provisions are there, they do not explicitly authorize the Attorney General to carry the office of independent counsel, virtually free of ongoing oversight. The circuit, nevertheless, at the time, says read them as accommodating the delegation at issue here. And then the court stated in an attached footnote that Nixon presupposed the validity of a regulation appointing the special prosecutor. No, there was no analysis of the statutes was provided, so there's nothing to go off of. And then more recently, this is in the matter of the grand jury investigation from 2019 in the D.C. Circuit. The same circuit court addressed a challenge on the authority of Special Counsel Robert Mueller, and remember the witch hunt there. A contemporary special counsel serving in a role akin to that of Jack Smith. The court characterized the abbreviated statutory authority remarks from Nixon in a sealed case as binding, reviewing them as necessary antecedents to the holdings, and then relying found no further analysis of the statute necessary. They say, though, as the foregoing discussions demonstrate, that the sealed case and grand jury investigations relied on presuppositions and antecedents to determine that Nixon, which itself did not engage in the applicable statutory text, was dispositive and foreclosed any challenge. Because remember, they're saying Nixon controls, but you're like, Nixon doesn't actually do anything. So how do we use it? They say, but as explained above, the Supreme Court's cautioned this kind of thing. And if you're doing of this sort, you're binding in future cases that directly raise the questions. Say, unlike Nixon, this case does directly raise the statutory authority question. And because neither outer circuit case considered this question in a meaningful way, the court doesn't find them persuasive. Remember, only persuasive. They can't force you to accept the rulings. They can't force you to accept the rulings. Trying to find somebody. What the heck? All right. Now we're going to keep going here. So she's saying in sum, the passing remark is not standing as binding precedent. So it's clearly not meant to be there. And I think that's a fair argument. Germ says, Your Honor, President Reagan set me up to fail. Yes. Yes, sincerely, Kata. I'm sure that's not going to be an acceptable argument. So let's keep going, though. The principal versus inferior officer designation. It brings to the final point of the Appointments Clause challenge. Prior to addressing remedy. Up to this juncture, the court has proceeded under the premise that he's an inferior officer and not a principal officer. The defendants in Edwin Meese contest it. And it's a point worthy of consideration given the virtually unchecked power given to Jack Smith under the special counsel regulations. And yeah, that actually is a fair thing to look at there. Ultimately, however, after examining the law, the broad language and seeing a mixed picture, even if a compelling one in favor of a principal designation, the court elects reservations to reject the principal officer's submission and leave the matter for review by higher courts. So she's punting on an issue here. She's punting on an issue. So the arguments on the motion developed a further argument as follows. Special Counsel Jack Smith contends he's an inferior officer because he's subject to supervision and oversight by others appointed by the president with Senate consent. They cite the factors. He's subject to removal by a higher executive branch official for good cause, as was the case for the now defunct Independent Counsel Office. He is empowered to perform limited duties within a limited jurisdiction that is temporary and expires when the charge is over. And 3, he reports to and is supervised by the Attorney General. 4, when all else fails, the Attorney General can move the accident regulation and create at-will removal by amending or eliminating the regulation or amending the self-appointment order itself. But it's not that quick to blow rules. They have to go through notice and rulemaking, and they have to go through procedure to do that. The defendants take the principal officer view, and they argue that he wields the same authority as a U.S. attorney without a functional supervising superior directing him, without the important tool of at-will removal. Because he can't be removed at will. So legal standards. The Supreme Court has not put forth a test distinguishing the two types. The court said it's not exactly clear where the line falls, but it enumerated a couple of factors. Are you subject to removal by a higher executive branch official? Well, obviously the president's higher, but they mean by can the Attorney General remove you? Okay, well then you're probably an inferior. 2, are you empowered by the act to perform only certain limited duties? Three, are you limited in jurisdiction? And 4, is your office limited in tenure or appointed essentially to accomplish a single task? So that said, though, Justice Scalia criticized this view and argued that the independent counsel was not subordinate to another officer and was only removable for good cause. And that's true. The independent counsel was pretty much bulletproof. I know there's I'm just going to leave it alone. There's something I can say that I'm not going to do. They point out that 10 years later in Edmund, because this was Morrison was 88. This is 97. So we're in the aftermath of Ken Starr running around. They fleshed out various issues involving the Coast Guard's Court of Criminal Appeals. So the bulk of the majority's analysis contained the passage was quoted below, although further important considerations, removability at will and power to render final decisions feature. So they point out that issue. Whether one is inferior depends on whether he has a superior. It's not enough that other officers may be identified who formally maintain a higher rank. That's not enough. Rather, it's designed to preserve political accountability relative to important government assignments. Inferior officers whose work is directed and supervised and settled by others who are appointed by presidential nomination, with the advice and consent of the Senate. Continuing forward, the decision stressed the power to remove officers is a powerful tool for control, noting that the judicial officer at issue was removable without cause, and that in officers' decisions, the degree in which they can be reversed or countermanded ultimately concluding that judges at issue remained inferior because their decisions were still reviewed by a higher court, and because they lack power to render a final decision on behalf of the United States unless permitted to do so by other executive branch officers. So from these questions, courts have distilled the three factors. Is whether the officer is subject to a substantial supervision and direction of a principal officer, whether an officer is removable without cause. That's probably one of the biggest things here, the weightiest factor. And then 3, an officer's decisions are subject to reversal by a superior in the executive branch. Those are critical. They say again, though, the Supreme Court has been careful not to create a rigid test because they don't want one. They use a case-by-case analysis. Once again, your boy, Clarence Thomas. So they talk about the discussion here, and we get through all of it. And she says that the special counsel regulations impose no supervision or direction on the special counsel. They say special counsels are no regulatory obligation to consult with the attorney general about the conduct of their responsibilities. So they point out special counsel must comply with the rules, regulations, procedures, and practices and policies of the department. And he must consult with appropriate officers for guidance. Guidance respective to those practices. She says, but nothing in that general policy consultation directive, a directive that only applies to consultation with appropriate officers, appears to limit a special counsel's specific decision-making and collection and conducting his investigation and prosecution. And that's true. There's no limit to saying what he can do or can't do. Third, on the subject of consultation, the regulations give full discretion to the special counsel whether to consult directly with the attorney general, even when the special counsel concludes the extraordinary circumstances of that decision would render compliance with the required review and approval procedures by the DOJ, whether they consider them inappropriate. You kind of give them free rein there to do things. Very weird, but I think that's kind of funny in another way. So even in these difficult circumstances, the special counsel is the one to decide whether to consult directly with the attorney general, again, leaving no mandatory consultation in the regulations. And then they say turning to mechanisms for notification between the attorney general and the special counsel. The regulations require that he notify the attorney general of events at the course of his investigation in conformity with department guidelines as like an urgent report. But nothing actually requires him to do anything other than notify the attorney general with certain developments. But what are non-exhaustive major developments? What are urgent reports? And they only impose a reporting requirement and notice requirement. You know, that's an issue. And nothing in this provisions give the attorney general any authority to actually countermand, direct, or supervise these decisions. So the attorney general, he can't countermand that guy. If the special counsel does something, the attorney general can't stop him. Well, if he's not legally allowed to countermand, and I'm not saying, things get filled out before Jack Smith leaves the office, he slaps a note on the counter. It says, anybody who flips over this paper and tries to stop me in court is gay. And everybody's like, well, I guess I don't want to be called gay today, so I'm going to pass on that. Then they say, finally, the regulations expressly remove day-to-day supervision and provide almost no countermanding authority for the attorney general. So there's a lot here. This leads the Attorney General to a very slim route to countermand the decision by the special counsel, but only when the decision is so inappropriate or unwarranted to, it's done that way. Is so inappropriate or unwarranted under established DOJ policies. Although, what do they say now? Be like, that policy's racist. Well, I guess it's good. Only if the Attorney General is given as a mandatory matter great weight to the views of special counsel. And remember, the Attorney General is subject to strict congressional oversight, and he has to notify decisions countermanding anything. So, this is so. Where does this leave us? Well, now there's a problem. It's hard to see how this amounts to any meaningful direction of supervision. And it certainly doesn't mean the special counsel lacks the power to render final decisions on behalf of the United States. I mean, that's a very important saying, consult these nuts. Yeah, thank you. I'm not going to consult them. Let's see here. Where else do we got? Nope, that's all caught up there, all caught up on these chats. So this saying that he is not directed and supervised by the Attorney General. And I think that's a fair argument. Who is he supervised by? Well, who is in charge of him? If the Attorney General's not in charge of him, then there's a problem. And I talk about the ability to remove him. It's very limited. This power to remove officers without will is a powerful tool for control, and it truly is. Oh, Alyssa got demonetized again? Yeah, that happens a lot. Sorry, Alyssa. They talk about it, though. These features are prominent, but these two cases actually contradict each other. Emmett and Morrison. I'm trying to think here something. I get the feeling without watching Kurt, I'm assuming this is where he's actually going to be having his biggest problem here. So that's probably the biggest part where okay, hold on, chat. I got another call here. Hold on. Yeah. Hold on here. I need to take this chat real quick. Sorry, guys. I am so sorry. So sorry. I haven't heard. Okay. So anyways, let's keep going. The removal for the special counsel regulations. Special counsel may be disciplined or removed only by personal action of the Attorney General. The Attorney General may remove for misconduct, dereliction of duty, incapacity, conflict of interest, or for other good cause. Okay. And good cause is a far-reaching term that is difficult to define. And yes, it is. A good cause is one of those words that it's what does that actually mean? Well, it means a lot of things. It means whatever I want it to mean. I think okay, perfect. All right. Sorry, 2.0 needs something printed out, chat. What is clear, however, is that the regulations do not afford the Attorney General at-will removal power. So if it's not at-will removal power, then who is he? And what is he? So what do you make about the removal limitations? On this point, the court argues with the district court in Concord Management that the special counsel regulations afford more substantial protection against removal and thus risk rendering him a principal officer. Because remember, who can remove a principal officer? Not him. And the reasons stated above, the court need not expound upon the analysis except further underscore the Supreme Court's strong emphasis on at-will removal as a powerful tool for control. Except, they say in Morrison, the court deemed independent counsel an inferior officer despite a good clause removal restriction. So there is a bit of an issue there. How's that going to work? Germ70 says, or actually over on Rumble, Fed Post Maximus for $2 says, Sean. I read your thread for the first time because of the drama. Very mimetic name. No Star Wars girl did not leak messages to Ralph. Enjoy prison. Well, thank you, Fed Postus. In German saying perhaps Congress should pass some actual legislation. Instead, the government just let things slide for decades. Yeah, but that's kind of a theme. Congress doesn't like fucking doing. Remember, government doing its job. That is like an inherent thing for all government employees. Not doing their fucking job. Yes, playing hard to get. I'm holding out for a SCOTUS nomination. Believe it or not, every time Trump was getting ready to appoint someone, I mailed in an email. I emailed, but I also mailed my resume and a writing sample for SCOTUS. Sadly, he didn't accept it. And I thought I wrote really banger cover letters. Like I did, no shit. I no shit did. Lamau, I don't think, I mean, why are you laughing? I was fucking serious. I wanted to get on Supreme Court. Is there a restraining order now? No. Not yet. Nobody came to me with one. So they're saying that in the context of multi-factor approach, that did not delineate the line between principal and inferior. And while it seems that the absence of an at-will key removal is key, it could likely transform when there's no meaningful supervision or countermanding authority, the special counsel could transform a principal officer. And the court holds off on that view to allow whatever evaluation of this topic may be conducted by higher courts. Interesting. I mean, what would happen? I'm assuming this is probably the one spot where Kurt really disagrees with it. I'm just guessing. Like I said, I don't know for sure. And I know Kurt's super smart guy. So he may disagree with another spot, but I'm assuming it's this area right here Kurt is starting to have problems with. I don't know, though. I mean, that is a bit of an issue. You can't tell him what to do. You can't stop him. And absent him acting like a fucking lunatic, how do you get rid of him? You can't. I mean, it sounds like an at-will guy. That sounds like a principal officer. So I wonder if that's where Kurt's got an issue. I'd love to ask him because, well, maybe I'll go back and listen and then I'll maybe see if him and I can talk. But I wonder how that works. I wonder how that goes. So they talk about one final issue relating to removal. It concerns the special counsel's fallback position that none of the removal limitations pose an impediment to inferior officer status because the attorney general can rescind or amend regulations at will and without notice or comment, and can amend or revoke the appointment order. In a nutshell, the submission is as follows. Evaluate the status of special counsel in accordance with the regulatory framework, but if the removal issue gets too sticky, customize that framework, consider the matter under a hypothetical future scenario where the regulation as is stands today. Well, she's saying, in other words, Jack Smith's argument is rely on the regulation for some things, but discard or amend them should they cast doubt into Jack Smith's inferiority status. So she calls this regulatory cherry picking. And yeah, I kind of see where she's getting that from there. So that is yeah. I don't see how it's going to work there. I don't see how she's going to do that. So, of course, regulations can be amended subject to ordinary legal principles and applicable restraints. But regulations have the force of law, so as long as they remain operative, which they are here, that you have to deal with them. The question is not whether the regulations can be rescinded or amended, they can be. But rather, the question is whether Special Counsel Smith is a principal or inferior officer. And that inquiry must operate on the basis of the extant law, not some possible future material change to the removal limitations. That has not happened. If the matter were otherwise, the result could be one of regulatory shielding. Almost in a figurative sense, an officer without authority to act as a principal officer exercises a principal officer role, but no means exists to test it in the noncompliance. Because the reviewing court, despite finding the principal status, must suspend reality or reject the challenge on the basis that it could get fixed. If he was acting pursuant to statute, the court would review the law in the fixed manner and go from there. But they wouldn't allow him just to keep hiding behind the law and say, oh, well, we'll change the law and make it work. Because that's Jack Smith's argument. Well, there's problems, he can fix it. Well, if that was the case, we never have any problem before there. Condoleezza said Andrea Burkhart reviewed this yet. I don't think so. I don't think so. And she's just saying all this simply underscores the need for Congress to do its job and enact a law. The final component concerns his jurisdiction and tenure. While Edmund did not stress these, the court considered them in reaching the final conclusions. The Independent Counsel Office is limited in jurisdiction and in tenure. What they yield here is muddled and likely not dispositive. Jack Smith's jurisdiction is limited in the manner described by the Attorney General, as compared to a United States Attorney with jurisdiction to investigate any violation of federal criminal law throughout the district. But his powers within the jurisdiction are exceedingly broad, indeed as broad as possessed by a U.S. attorney. And in some degree, his powers are arguably broader than a traditional U.S. attorney, as he's permitted to exercise his investigatory powers across multiple districts within the same investigation. So is he really exercising limited jurisdiction? Jack Smith could go anywhere or do anything. He could file in any jurisdiction as he sees fit. The issue is the answers are hazy. In any event, the officer's scope of work, even if limited, is not dispositive to the jurisdictional inquiry. What happens from here is that, in Morrison, they exercise more power, more than the full power of the Attorney General. The ambassador to Luxembourg is not anything less than a principal officer, simply because Luxembourg is small. And the federal judge who sits in a small district is not for that reason inferior or rank or authority. And the judge, a federal judge in Wyoming, is no less important than a federal judge in the District of Columbia. So that is the argument they're making here. So I think it's a pretty good point. It's a pretty good point. If the mere fragmentation responsibility in the small compartment suffices to render the heads of each inferior, then Congress could deprive the president of the right to appoint his chief law enforcement officer by dividing the attorney general's responsibilities up among a bunch of lesser functionaries. And it could be the attorney, it'd be like the executive VP for this, the attorney general for this, and this. And he says that's not allowed. As the tenure, while it's true that Jack Smith's position will end at the conclusion of his work, when the hell is that going to happen? That's not a limited time. When are you done, Mr. Smith? When I'm done. It's like, okay. Like, when do you go? And there's no case law about an unlimited tenure benchmark. What is known, however, is that he's been operating since November 2022. He's established a very significant operation in terms of staffing and resources. He's used almost $13 million. And nothing in the regulations or appointment order or the record provides a concrete sunset provision. So here's the thing. He's got limited jurisdiction, means he can something less than a general U.S. attorney, but he can fucking go everywhere. His tenure is limited if requires an open-ended appointment, perhaps with a fixed number of years. But this is all unclear because this is something we don't have. But because of this, the court sees compelling reasons to reach the principal officer designation. But because the answer under SCOTUS precedent is not self-evident, and because this court need not rely on this grounds to dispose of the Appointments Clause challenge of the motion, the court elects to leave the matter for future review. So, of course, however, should it be determined that Jack Smith is a principal officer, his appointment would violate the Appointments Clause without question under Article 2, Section 2, Clause 2. So, what's the remedy? Oh, Cat Williams viewers, hi guys, thanks for joining. What does this do for us? What's the remedy? And we're going to get through this. We're finishing up here, chat. See, 81 of 93. We're almost home. The court turns, what do we do about this? Well, the defendants seek dismissal of the superseding indictment, arguing Jack Smith lacks the authority. Okay. Special counsel opposes the request, but fails to propose an alternative form of relief or respond to the substance of the question. They say because the special counsel is authorized to carry out the prosecution, the court has no reason to consider whether special counsel's actions to date are salvageable. They're saying because his exercise of prosecutorial power has not been authorized by law, the court sees no way forward aside from dismissing the superseding indictment. And Jack Smith doesn't propose an alternative. And they point out if you make a timely challenge to constitutional validity regarding an appointment, you're entitled to relief. So, in cases and that's fair. You have to do it timely, and they did do it timely. It's like many things; you have to raise it in a timely manner. Now, when necessarily involve a government actor's exercise of power that the actor did not lawfully possess, the proper remedy is invalidation of the ultra vires action, meaning one that was excluding his power and scope and his authority. Invalidation follows direct from the government actor's lack of authority to take the challenge action in the first place. winning the merits of the constitutional challenge is enough. So, in light of these principles, because the court concludes Jack Smith violates the Appointments Clause, meaning it violates the Constitution, there's no way to fix it. And they go to a case, Lucia versus SEC. In Lucia, the petitioner challenged the judge's appointment for some SEC violations. The court sided with him, saying that the judge's appointment was constitutionally defective under the Appointments Clause. And because the judge had already heard and decided the case, the court ruled the appropriate remedy for an adjudication tainted with appointments violation is a new hearing for a properly appointed official. Basically, it undid the unlawful action by granting him a new hearing before somebody who was lawfully appointed. So they're pointing out the appropriate remedy here is a validation of the act. And they're saying that he had power he did not lawfully possess. Okay. And the court sees no alternative course to cure the problem. So where are we left with? Well, Jack Smith is saying, wait, time out. I'm going to make an argument under the de facto officer doctrine, which allows validity on acts performed by a person acting under the color of official title, even though it's later discovered they didn't the legality of it is deficient. Look, I thought I was good, and I was acting under the Attorney General. Isn't that good enough? The judge says, nope, does not apply here. Except first, the doctrine is designed to address technical defects entitled to office. This isn't a technical defect. The problem is the absence of statutorily created office to fill in the first place. The Supreme Court makes it clear there can be no officer, either de jure or de facto, if there is no office to fill. And they say, second, de facto officer doctrine has not been applied in this case. Like this one, where a litigant raises a timely constitutional challenge to the officer's appointment. So they do keep to move on, and they point out a little more further. Any other rule would create a disincentive to raise appointments clause challenges in the face of questionable appointments. Because yes, if you can raise it, they didn't appoint this guy properly, violates the Constitution. Oh, well, don't care. It's all right. There's nothing they can do. There's nothing they can do. Now, like I said, she doesn't say he can't come back, and she doesn't say it doesn't work anymore. But because there could be no valid officer without a valid office, the court sees no basis to resort to the de facto officer doctrine. So there isn't any office for him to be in which they could remedy the appointment. So that's it. That is it, guys. It's done. It's done. Hi, Cat Raiders. Yes. Hi, Cat. So that is the limit here. The judge is just saying that. Now, that doesn't mean it can't get reworked. Like I said, this is a procedural dismissal. If things are done the right way, there's no stopping it from coming back. So the case isn't thrown out forever. This case could get re-indicted. But because Jack Smith, everything he didn't have the authority to do, think about it. If you are not a prosecutor, but you walked in front of a grand jury and you got an indictment, aside from like impersonating and all that, you got the grand jury to indict somebody. That grand jury indictment would not be valid. I mean, it makes sense. It does make sense. This is an issue that hasn't been fully addressed. And yeah, I guess the other thing to think about is, well, we haven't had this happen before. The court hasn't ruled on it. Yeah, but this is actually a fairly decent argument. Like, we should apply by the fucking rules or not. Let's see. Now, the Appropriations Clause, all about money. So Jack Smith has been funded by a permanent indefinite appropriation established within the DOJ to pay all necessary expenses of investigations and prosecutions by independent counsel appointed pursuant to 28 U.S.C. 591. But as discussed above, because Jack Smith was not lawfully appointed pursuant to other law, that means that he has been illegally drawing funds from the Treasury without authorization. And this is typically if cases implode, you address the argument that causes everything else. It's like boom, it flattens it. Now that implodes. So that's how it's falling apart. So the appropriation clause, no money shall be drawn from the Treasury, but in consequence of appropriation made by law. And it means no money can be paid out of the Treasury unless it's been appropriated. The appropriation only need to identify a source of funds and authorize the expenditure of those funds for a designated purpose. So these appropriations play a critical role because without it, Congress loses one of its biggest things, the power of the purse. President wants to do something. Congress say, fuck you, I'm not paying for it. And then the president's like, shit. And he's stuck. It's that role that they all play. They all have the roles they play. It's almost called role playing. All three sides fighting each other. So, as historical matter, Congress's power over the purse has been its most complete and effectual weapon. Yes, money makes the world go round, chat. Money makes the world go round. So, by its terms, the indefinite appropriation is available only to independent counsels appointed pursuant properly under the Independent Counsel laws. The Independent Counsel Act expired in 1999, meaning that Jack Smith must identify other law authorizing his appointment to access the indefinite appropriation. Both sides agree that other law for present purposes is the collection of statutes cited in the appointment order. And that makes sense, like we're using the law that's already been cited. And they're saying for all the reasons the court found no statutory authority for the appointment, Special Counsel's investigation has unlawfully drawn funds from the indefinite appropriation. And having found no other law, the court need not determine whether Jack Smith is the type of independent counsel referenced in the indefinite appropriation. She said, I don't have to look at it because I already said he's not. And therefore, he can't take money as independent counsel. So this part here, guys, the real issue is everything she decided way up this way. Because down here, this is just a simple matter of if he doesn't qualify as any of that, then he's not entitled to the money that's listed. Nevertheless, the court notes the inherent tension in the special counsel's position on this issue. In the appointment clause context, he's arguing that he is an inferior officer. Yet in the appropriations clause context, he asserts he's sufficiently independent to draw funds from the independent appropriation. In other words, Jack Smith contends he is independent enough to access the funds, but not so independent enough to constitute a principal officer. And she says, you know what? Maybe he threads that needle, but I'm not sure. And she says, in 2004, the Government Accountability Office approved Special Counsel Patrick Fitzgerald's use of funds from the indefinite appropriation. Special Counsel and permanent indefinite appropriation, the determination was grounded in his express exclusion from the application of 28 CFR 600, which allowed him to operate independent of supervision or control any officer. So they're saying that there was like one time, and I think that's the Barley Plain investigation. Yeah, let me see here. Yes. So if you guys remember the Valerie Plame affair, where Valerie Plame was a CIA agent, she was married to, what the fuck was that guy's name? He was the husband to a diplomat, and she was running around doing spook stuff for the CIA. Well, a reporter, Robert Novak, leaked her name and disclosed it, blew it all up, destroyed her career as a CIA spy. Eventually, there was an investigation into that, and that led to Scooter Libby and going to prison over obstructing that investigation. And Patrick Fitzgerald was a special counsel charged with investigating it. Black Horse Calvary, you saying, nice to see you here. I think you're new, so thanks for stopping by. Saying, does this mean that Trump's DOJ could arrest Jack Smith next January and charge him with theft of public funds? No. I think he would argue he had a valid and reasonable enough reliance on the idea that I was allowed to do this. So no, I don't think he's stuck with that. So just saying. Yes, and W did pardon Scooter Libby, but that was after he had already gone away. Michael Boyle says Joe Wilson was the husband and Scooter Libby had documents in his pants. No. The guy with documents in his pants was oh, what was that guy? Classified documents in his pants. Sandy Berger. He was former national security advisor to Bill Clinton. And he took stuff out in his pants regarding 9/11 as part of the 9/11 investigations. So, but yes, he's not going to prison. Jack Smith is not going to prison either. They say contrast Fitzgerald with Special Counsel Smith by the express terms of the appointment order, by his own admission, is subject to the Special Counsel regulations and subject to supervision and control of Attorney General. As mentioned above, the court need not decide independence given the absence of statutory law authorizing the appointment, but at least the independence question raises doubts. And she says this leaves the remedy for the Appropriations Clause violation. There's only one way to cure the funding dismissal, according to Trump. Jack Smith opposes dismissal, asserting that the department could have readily funded the special counsel from other appropriations that were available. At the hearing, Jack Smith said at a relatively high level of generality that DOJ has appropriated, at least in the 2023 cycle, over $1 billion, which it is used to prepare to fund the special counsel's office. The court need not reach the question of remedy here. We found the appointments clause violation to warrant dismissal. But as discussed below, there's good reason to believe that the appropriation clause violation serves as a separate independent basis to dismiss. And I disagree. I think they can change it because they can say, look, DOJ's got all kinds of money it can give me. And she says, as far as this court could tell, as far as I can tell, there's no Supreme Court or 11th Circuit precedent that speaks directly to this point. Yeah. She's like, there's nothing for me to go on. Given the absence of binding precedent on the issue, the court finds instructive a Fifth Circuit judge, Edith Jones, in this case, here, the Consumer Finance Protection Bureau versus the All-American Check Cashing Incorporated, a case involving civil enforcement action brought through the Consumer Finance Protection Bureau. There was a question whether or not the structure of the CFPB violates separation of powers. In a per curiam opinion, the court vacated and remanded the district court's order in light of this. The judge concurred, writing separately to make the case that CFPB's funding sorry here, guys. Sorry, I was trying to read that. Funding mechanisms violate the Appropriations Clause, likening an unlawfully funded enforcement action to an unauthorized government action. So she advanced that dismissal was a proper remedy. And that's fair. You're arguing that, and it's fair to make that argument. I think so, but I still think the DOJ's argument of we could just grab the money from somewhere else is a fair argument. Because I don't know if I necessarily like this, that just as a government actor cannot exercise power he doesn't lawfully possess, the government actor cannot exercise even lawful authority using money the actor cannot lawfully spend. Fine. Turn around and cut another check, draw from another account. I don't know if this is I don't think this is actually proper, Judge Cannon. I think Jack Smith's right. Like he said, they have $1 billion ready to go. A billion with a B. Ready to go. They can use money they can draw from. I mean, you can sure as shit be confirmed Merrick Garland will want to prosecute Trump. They will make the money happen. They'll forgo salary, I bet, at the end of the day. So that's why I don't think this is appropriate. I don't know if remedy is the appropriate, or dismissal is the appropriate remedy here. I just don't think so. That said, though, the judge involved in this says that when a government actor took action without authority, the appropriate remedial course was to disregard the government action. And I don't necessarily disagree with that. But I think Jack Smith could say, well, we could fix this really quickly. And she says there's a strong intuitive appeal to applying the logic here. You know, the funding has served as the very lifeblood that empowered it to act. Yes. Perhaps it's suggested generally at the hearing. The DOJ could reallocate funds to continue the continued operation. Okay. This should require further development of the record. But even if this were possible, what to make of the prior action? For 18 months, Jack Smith investigated and prosecuted has been financed by funds drawn from the Treasury without authorization. And to try to rewrite history at this point seems near impossible. The court sees difficulty seeing how a remedy short of dismissal would cure this substantial separation of powers violation. But the answers are not entirely self-evident. Okay, well, if they're not self-evident, I have difficulty seeing it, but they're not self-evident. Judge Cannon, how you don't, those don't work together. Case law is not well developed. For that reason, and given the disposition's order on the appointments clause grounds, this court leaves a matter of funding for remedy for any applicable future review. I'm glad she didn't make a statement here because I don't think it's improper. I mean, if there you could cite a dismissal, but if I could fix it, would you really want to restart everything? I don't think so. I don't think you would. Robbie Blair says, why didn't she use one sheet of paper and write dismiss because I say so? Because so far she hasn't. Her issues with the appointments clause, I think, are pretty good. But this appropriation stuff is nonsense. And then we get to the conclusion. It says, motions, the court is convinced special counsel's prosecution breaches two structural cornerstones of our scheme: the role of Congress in the appointment of constitutional officers and in authorized expenditures by law. So it's just, and I think this is actually a really good way she ends this here. In the end, it seems the executive's growing comfort in appointing regulatory special counsels in the more recent era has followed an ad hoc pattern with little scrutiny. Perhaps this could be traced back to the reliance on the stray dictum in Nixon that perpetuated in subsequent cases. Perhaps it can be justified practically by the urgency of national crises. Or perhaps it can be explained by the relative infrequency of these types of investigations by congressional inattention, which I think is a big one, or by important roles that special counsel-like figures have played in our country's history. Regardless of the case, the motion requires careful analysis of the statute, and to ensure compliance with the Constitution, this court has endeavored to do so with care. J.D. Vance has taken the stage at the RNC. Where do you guys see him at? Yep. Okay. Well, we're going to finish up real quick and we'll watch that real quick, chat. So, thus the court returns to where it started. The appointments clause is critical. The appropriations clause is critical. And here she cites to Alexander Hamilton and Federalist number 78. The power of the purse is the executive control of the sword. Because if you can't fund it, you can't wield it. Kind of like an army. You don't have an army if you can't pay for it. So, and as Justice Frankfurter explained in the Youngstown Steel opinion, the accretion of dangerous power does not come in a day. It does come, however, slowly from the generative force of unchecked disregard of the restrictions that fence it, even the most disinterested assertion of authority. Meaning, this didn't happen by itself right here. This has been a slow building disaster. So, for the reasons above, it is ordered in a judge that follows. The motion to dismiss the superseding indictment is granted. The superseding indictment is dismissed. The order is confined to this proceeding. This order does not decide any of the rights or claims. This order does not affect or weaken any protections for classified information imposed in this case or any protective orders pertaining to it, meaning all the stuff you've had access to as part of Trump's team is not relieved from that. So Trump's attorneys can't go, hey guys, here's all the secret crap we had. Nope. All the rules regarding that stuff is in place and in effect. The clerk is directed to close the case. All hearings are canceled. Any pending motions are denied as moot, and they're done. Pending deadlines are terminated. Done and ordered today. Bam. Fiend. Judge Aileen Cannon, U.S. District Judge. That's it. That's it. So there we go. There we go. It's all over, chat. It's all over. Guys, where the hell is JD Vance? They have like a whole band up there playing. It's kind of funny. They have like a band in the back. It's like they have like a band in the back. So yeah, it's not bad. They got a band going. So he's making his way up there. Well, where the hell is he? Like, you guys are like, he's making his way up there. This lady's been standing here for like 5 minutes. Like, where are you, JD Vance? Like, let's go. Oh, he's tidying up his office for me. That's what he's doing. He's emptying it out. Well, guys, it's over in this is over in Milwaukee, Wisconsin. So we will I'll put up a little banner here. JD Vance is going to be the vice president on the ticket. And that's what we're looking at right now, chat. Hope the Secret Service is looking for Patrick Tomlinson. Ah! Aaron says, what do I think of JD Vance? I've actually had the chance to meet him at a couple of I've been at a couple of fundraisers where it's like, I will say, from my work as a lawyer, I've been able to get into a couple of these fundraisers where it's like 150 people. And I ain't cutting the checks these fucking people are cutting. I'm like, oh, are you here? Like, oh yeah, I donated like $20. I'm like, fucking throwing money in. These people are writing big old fucking checks. And I'm like, no, the brisket's real good. No, and I got to meet him, and he was actually, these were really good. Like, people were fucking hitting him hard. And these people, a couple of these people asked questions like, why did you not like Trump before? What's changed your mind? Yeah. Yeah. So it was very, very interesting in that regard. He kind of bullshit his way out of it, but hold on, we'll see. What's this?
With Rule 40 40B, the chair has been furnished with evidence that a plurality of the delegates from each of 5 or more states severally support the candidate who will be presented for the nomination for Vice President of the United States.
Okay.
The chair would like to remind delegates of the provisions of Rule 40A, which provide that in part, if there is only one candidate for nomination for Vice President of the United States who has demonstrated the support required by this paragraph B of this rule, a motion to nominate for such office by acclamation shall be in order.
Oh,
and no
fucking A. I
calling of
hate
the roll
fucking
with respect
Robert's
to
Rules of
such
Order.
office
Just
shall
kill
be
me now,
required.
chat.
At this time, the chair states that she has been furnished with evidence that there is only one candidate for
Because you have to follow
nomination
rules
for
of
the
order
office
and
of
procedure.
Vice President who has demonstrated the support required under Rule 40B of the Rules of the Convention. Delegates and alternates. The chair recognizes and is pleased to introduce
Yes, J.D. Vance is-
John Husted, Lieutenant Governor of Ohio, for the purpose of nominating. Please give him a warm welcome.
Yes, John Husted, our Lieutenant Governor. But anyway, yes, J.D. Vance is 39, and I'm going to be 39 in August. I feel like a fucking failure.
Are we ready? Are we ready to nominate a vice president?
Yeah, he does that. He does that. Are we ready thing? He
How
says
about
his
you,
W's
Ohio?
that weird.
Yeah!
We.
That's awesome. I'm John Husted, the Lieutenant Governor from the great state of Ohio. It is an honor to speak to you all this afternoon to formally nominate the Republican nominee for Vice
Let's see what
President
happens.
of the United States. Ohio is the heart of it
Yeah,
all.
poo. No.
And that is certainly the case once again here today. The vice presidency is an office of sacred trust. The man who accepts this nomination accepts with it the awesome responsibility to give wise counsel to the president, to represent America abroad, to preside
Why are
over
we
the Senate,
representing ourselves
and
to
to
broads?
be ready to lead our nation at a moment's notice. Such a man must have an America first attitude in his heart. He must, amen. He must embrace his obligation to the American family, the American worker, and the American soldier. He must believe that America is exceptional. And be prepared in the tradition of our founders to pledge his life, his fortune, his sacred honor to preserve, protect, and defend the Constitution of the United States. He must share the values and principles of our presidential nominee and be trusted to faithfully implement the will of the people. J.D. Vance is such a man.
JD, 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 JD.
Oh my God, just go.
JD, JD.
Oh God, so cringe.
A man who loves America and will represent our people with moral courage, strength, and honor. JD is a living embodiment of the American dream. He came from humble beginnings, and even as his life took him to places he might have never imagined, he never forgot where he came from. Ohio values are in his blood.
I mean, maybe.
He served our nation in the United States Marine Corps. He is a graduate of The Ohio State University.
Oh.
He graduated summa cum laude from Yale Law School and is the author
Boring.
of the best-selling book Hillbilly Elegy. and he is a crusader for the people of the Ohio in the United States Senate.
People of the Ohio,
He
what?
has never forgotten the working
The
people
Ohio
of
what?
our country, and he
Oh my
never
God, let's
will.
go.
He fought to bring investment to Middle America as a businessman and has fought to defend them every single day in the Senate. And this I know, he will faithfully stand by President Donald Trump's side as they win this election and change the course of our nation.
Okay, what's it going to be? Like, come on.
They will change the course of our nation to the benefit of all American citizens and truly make our country great again. It is therefore my honor to nominate Ohio Senator J.D. Vance for the office of Vice President of the United States of America.
I mean, he will beat Kamala's ass. It'll be great. That's the one thing, at least.
Delegates and alternates, pursuant to Rule 40A, a motion to nominate by acclamation is now in order. The chair now recognizes Delegate Bernie Moreno, Senate candidate from Ohio, for the purpose of making a motion.
Thank you, Madam Chair. My name is Bernie Moreno. I'm honored.
And you're going to get your ass kicked by Sherrod Brown, probably.
State of Ohio.
That's a sad thing. Sherrod Brown's going to eat your fucking lunch, Holmes.
I know firsthand.
I hope I'm wrong.
That my
I
dear
hope
friend
I'm wrong.
JD is a
I hope I'm wrong.
selfless and brilliant fighter. He is a patriot who loves America. He loves Ohio. He loves his family. He's a great father. He's a great man. And that's what we need in this nation today. The J.D. Vance, America First, is not just a slogan. It's his North Star. He has followed it every moment of his life and career. He knows what it's like to live in poverty, forgotten by Washington politicians. He is dedicated to ensure that no American is ever forgotten again. Madam Chair, it is a great honor to move that J.D. Vance be nominated by acclamation by this Republican National Convention as its candidate for the office of Vice President of the United States of America.
Without objection, the previous question is ordered. The question is on the motion that Senator J.D. Vance be nominated by acclamation. All those in favor signify by saying aye.
Yes, chat.
Aye!
Brave
All
J.D.
those
Vance, he got a
opposed
sex
signify
change.
by saying no. In the opinion of the chair,
I
the
would've
ayes
said
have
no.
it, and the motion is adopted. Without objection, the motion to reconsider is laid upon the table.
Okay, oh my God, this is boring. He's not coming out, chat. Like, I don't know what's happening. Oh, actually.
Proud to announce that
Okay, here we go.
Senator J.D. Vance has the overwhelming support of this convention to be the next Vice President
Let's
of
go.
the United States.
I was hoping he'd come speak.
The chair is pleased to make the following appointments to the escort committee for Senator J.D. Vance, his vice presidential nominee. Usha Vance, thank you, and God bless America.
Ladies and gentlemen, please welcome back Speaker Johnson.
What a great night. Pursuant to Rule 40D of the rules of the Republican Party, I formally declare President Donald J. Trump and J.D. Vance as the Republican nominees for president and
Okay,
vice
yeah,
president
this is
of the United
boring. We're
States.
done. I thought he was going to speak, guys. All right, yeah, loser. God, he said so much out there without having Ukrainian wiener in his mouth. So yeah, we're done, guys. We're done. Anyway, I think it's going to be interesting to see what happens with this because I think Judge Cannon made some strong arguments there. I don't know what it's going to turn into there. Mute audio will get a strike. Well, yeah. So yeah, anyways, he's not speaking. That's not happening right now. He looks like that Pierre Poilievre guy. Yeah, well, we'll see. Hopefully he wins and they kick him out to the curb. Hellcat says, yes, was Speaker Johnson sucking Zelensky off stage? Probably. That's what those guys do over there. So, Kale says, I have time to go pee. Yeah, well, we're wrapping up, so don't have to worry about a pee break. We're done. We are done. So, guys, it'll be interesting to see what happens going forward. But yes, I mean, as much as I want to say, like I said at the beginning, it's dumb city for Donald. It's good. It's better than nothing. But just take it in consideration what we're looking at. Yes, it's probably cleared out for the year, but that's it. Give me a couple minutes, guys. We'll probably start up something about Judge Glanville very soon. I'll read that recusal stuff and we'll get going from there. So, Sir Fitz says maybe the Democrats could pass a new special counsel statute. Well, remember, the Republicans control the House, and then for the Senate, are you going to get that through? Are you going to get that through in time? Like, even if you got it through right now, the whole process starts all over again. So, yeah. Ariel says, what about Earl Glanville? I'm going to restart. I'll start a new stream for that, but I need to go take care of some things, and we'll be back probably in about a half hour or so, guys. So at this point, I didn't think about, guys, we are going to be covering stuff. There's quite a bit to talk about tonight. Also, about 8:30 or so, I'm going to go live here on YouTube. We're going to have Joe Dolio and a couple other guys from Future Conflicts and some other people coming on. Kind of talk about some updates with the whole thing regarding President Trump's assassination attempt. It appears there were some inert explosive devices found in the area. And that's leading to an idea that maybe there was an attempt the shooting was merely to get him in the car, and the real attack would have been with a device. So, yeah, interesting. It's very interesting stuff. Very, 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 very interesting. That'll be later tonight. They were found in the douche's car. They found some others somewhere too, though. Some other stuff has been found based on information I've had there. So, do I have to poop? Maybe. Anyways, with that all being said, give me about a half hour. We'll fire up with Judge Glanville hitting the bricks because what better way to get rid of it? Watching on the website saying ahoy, ahoy. Yes. So we are all set. And guys, tomorrow, not sure we're getting into, but there's, all kinds of crap going on today. It's a big day. It's a day of days, chat. So take care, everybody, and remember until next time. And we'll be on throughout, guys. Also remember, if you are new, we do a live show every Thursday night at 9:30 Eastern. We'll be covering all this stuff, the dismissal, Trump, probably the RNC stuff because it'll be in full swing by then. Just everything. We'll be covering it and going from there. There's a lot of stuff that's already happened so far, and even more that's going to continue to happen. So, guys, remember until next time, especially right now, even if Trump did it, he's not guilty because the indictment went poof. So, Dark Horse says it doesn't feel like a big day. That's a pretty big day. It's a pretty big day, in my opinion. So, anyways, take care, chat, and we will see you later. Have a nice day. See you in about a half hour, 40. It'll be a half hour to go to do this. So, give me about a half hour, chat. So, take care, everybody.
blacksmithing and models of planes, esoteric works, and even some trains. Much merriment had while drinking White Claws, tips on hunting, and even talking the law. Whatever you do, just don't talk to cops, even when they nab you on illegal stops. Just 'cause you did it doesn't mean you're guilty, but please talk to a local attorney. Was that the fat guy Rick Hayden yelled at? Why, yes it was.